Adj- Adjournment request, if any, from item number 1 to 5.
Please, Lord. I'd like to mention item number 5. I was supposed to file a rejoinder affidavit, which I couldn't because the petitioner number 1 became ill. I pray for some more time.
Already we granted you many times.
Yes,
Opportunity
once
granted.
on the last occasion, my lord.
6 weeks.
From item number 6 to 13. From item number 14 to 22.
Lordship, item 14 and 15 on Monday, Lordship, 3 appeals were listed. Lordship, direct
On Monday,
on
we connected
total 7 appeals have been filed by department. 3 were listed on Monday, Lordship, directed to listed along with it after 4.
Monday.
Okay, I'd like to mention item number 17. Here we have engaged a new senior counsel yesterday, Your Lordship. Can we allow some time?
Item number 20, item number 22, my lord.
Yeah.
The state is to file a reply. I'm asking for 10 days time, my lord. Otherwise it come. I have informed the other side in the morning, my lord.
2 weeks.
Obliged.
Item number 23 to 34.
May I please, Your Lordship? With the concern from the other side, Your Lordship, I beg to mention item number 33,
PIL.
PIL.
Area, then. 4 weeks.
Great, Lord.
May I please, Lord, so with the concern of other side, I like to beg to mention item number 26.
Yeah.
Engaged counsel from Aizol is unable to come today. So your lordship may kindly fixed on 5th of September.
5th of September.
Obliged.
Yeah, please, the Lordship. Lordship, I beg to mention item number 32. Lordship, the engaged counsel for the appellants is out of station, Lordship.
Adjourn.
Obliged.
From item number 35 to 43.
May please, your lordship. With the other side concern, my lord, I beg to mention item number 38, my lord. 1 week's time may be given, my lord.
Adjourn.
My lord, so far time is concerned, your lordship may grant 2 weeks time.
2 weeks.
I'm sorry, my lord.
38, 2 weeks.
I'm sorry, my lord, I'm not on that. My item is 40, I'm sorry.
Item number 38, 1 week. Yes.
Your Lordship, I beg to make a mention for item number 39, 40 and 41 of the daily list.
Yeah.
Your Lordship, there is a settlement process going on between the parties, Your Lordship. I request that the matter may be adjourned for 4 weeks, Your Lordship.
My lord, in regard to that, my lord, regarding settlement, I don't have any instruction. However, my lord, if they really want to settle the matter, 15 days time is enough. So your lordship can grant 2 weeks time.
3 weeks.
3 weeks.
All right. I'm obliged.
Your Lordship, there is an interim order in item number 40. May that continue?
I remember, you just see if there is an interim order.
Item 40.
Interim order passed in front, so the
Highly obliged. Your Lordship.
Obliged.
yeah.
The concern on the other side, I'd like to mention 44 and 45. I'm appearing on behalf of Mr. R. Goenka. He's out of station. This matter may be taken up
Adjourn.
the
6
second week of September.
6 weeks. Yes.
Fine, my lord.
Any other request?
May I please, your lordship, my lord, I beg to mention for listing, my lord, on Monday, next Monday, 19/8, my lord.
What's the urgency on Monday?
But the urgency, my lord, the learned.
What's the matter about?
My matter about suspension of my license, fair price shop license, my lord.
License for
Fair price shop, my lord.
Monday.
Monday, obliged, my lord.
My lord, there is a humble request. Earlier, yesterday I have made a mention about the lumbering division, your lordship. Now the file is in filing section and I have got the file number also, filing number.
Ma'am,
Your
you
lordship,
have not provided details yesterday. They were looking for you.
Because your
You
lordship,
have not provided any
Your lordship,
details.
because the certified copy was not obtained from the office, your lordship,
Then
that's
why
why.
you made a mention here?
For today, your lordship, your lordship have accepted for the tomorrow. Your lordship, it is in the filing section. We have got the filing number, your lordship. It is the stake of the 2,000 people.
Maybe you
Your
mentioned that matter yesterday and you have not provided the
Your
details.
lordship-
What can I do? What
lordship-
can we do now?
Your lordship, just now we are providing because the filing number is obtained.
Monday,
Your lordship, it is urgent matter because the
whatever it may be, urgency, ma'am.
15th is
once
the, your lordship,
We granted you permission for today.
your
You have
lordship,
not given the details. What can we do?
your lordship, today, your lordship kindly permit
Not
because
today.
at the
Today.
stake of the 2,000 people live,
Friday, that's all.
your lordship,
Not today, ma'am. No, sorry,
your
ma'am.
lordship,
It's not possible.
your lordship, on
We have already granted you permission yesterday
Friday.
for listing
Friday.
it today. You have not provided the details. What can we do?
my lord, my lord. On Friday, your lordship,
Friday.
deeply blessed.
Supplementary list, item 46 to 48, under heading to be mentioned.
Mr. Sahewala,
My lord,
what is this mess here? You have, which order you have annexed with the petition?
the order which was
Have you
sent,
gone through the file?
my lord.
Have you gone through the file?
My lord, the one
The
order, is-
appellate authority has remanded the matter. What happened thereafter?
it was remanded back, my lord, that
Then what happened thereafter?
it was again rejected, my lord.
Where is that order?
Order is missing, my lord.
Then
My lord, order is
how can
missing,
we do that,
my
sir?
lord. Where,
How can we adjudicate the matter in another matter? No such orders are there
my lord,
by the original authority or by the appellate authority.
My-
Orders are not there.
my lord.
Then how can we decide that?
We'll bring into record, my lord, but otherwise, my lord, there is one order.
Okay. The matter was. These matters were heard finally on 6/8/2024 and the order was reserved. However, while going through the file, it appears that the order impugned passed by the CTET is not annexed with the with this application, excise application, excise appeal. With the excise appeal number 4/2019. Full stop. In another appeal, the orders passed by the authority, by the original as well as the appellate authority have also not been annexed. Full stop. In such circumstances, it would be difficult for us to adjudicate the controversy raised in this, in these excise appeals. Stop. Hence, the matter will still, after 4 weeks, while not treating it as pattern. In the meantime, the counsel for the appellant may cure the deficiencies
Deeply.
noted above.
Daily list for orders, item 1 to 4.
Your lordship में
Yes,
your lordship may kindly peruse order dated 16/11/2023
order
And-
dated
16/11/2023
16/11/2023.
and 28/2/2024, two orders.
Yes. And another order is
28/2/2024, your lordship.
Arbor Council appearing for the 3 weeks time, more time to place on record the proposed plan for systematic placement of vendors in thickly populated areas.
Now
Yes.
that instruction has not come up here. Still.
Mr. Barua, GMD,
Lordship, in fact, in item number 1, which PIL 15 of 2021,
yeah,
we have already filed one affidavit that notification by which the town vending committee was constituted has been brought into record. That is their Lordship.
sir, systematic placement of vendors in
Lordship-
thickly populated, where is that
Lordship-
plan?
Yes, that town vending committee so far identified 81 vending zones, Lordship, wherein 6465 numbers of vendors can be placed. That is under process, Lordship.
Where is your affidavit?
It is in PIL number 15 of 2021, item number 1. Lordship. It's affidavit dated 3rd of May 2024. Category.
Second part.
Page 33, Lordship, paragraph 4 and paragraph 4.
Which are those 81? This
Lordship,
vending
page
zones?
33, Lordship, paragraph 4, sub-para, Lordship. Page 33 of my
But
affidavit.
where is that 81 vending zones?
Yes.
Which are those vending zones?
Paragraph 4, yes, Lord, paragraph 4.
Mentioned, but where is the mention of these vending zones? Which are the places?
Places are not mentioned here, Lord.
Why?
That notification. Here, I have only mentioned that 81 vending zones have been identified.
Which are those 81 places? Which have been identified as a vending zone?
Lordship,
Which are those? places?
Lordship will grant me sometime, Lordship, I'll furnish that.
So at least it must be on record and then you, and what is this first phase and second phase?
Yes,
You have started shifting those vendors or not?
that instruction is also awaited, Lordship. In fact, this affidavit was filed in the month of May, Lordship. Thereafter, I have not,
5 months almost,
Lordship, one
3
week time,
months, 3 months almost.
yes.
So now what is your plan or how to,
Lordship, grant me 1 or 2 week time, Lordship, I'll file a detailed affidavit, Lordship.
whether you have provided the facilities which you propose to give them on the vending zones or not?
Lordship,
What is there?
Lordship,
You have to develop that place for that purpose.
Lordship.
Simply by identification will not sufficient. Identification is only not sufficient.
Lordship.
You have to provide some amenities there.
Understood, Lord. Lordship, I will file one detailed affidavit.
Phase 1 should be allocation of timeline.
Pursuant to the direction given by this court on 28th of February 2024, Mr. P. Nayak and counsel appearing for the Guwahati Municipal Corporation.
GMD, it is GMD, is it?
This affidavit has been filed
By the
GMC.
municipal. Joint Commissioner Municipal Corporation. Guwahati Municipal Corporation has submitted that an affidavit on behalf of the Joint Commissioner of GMC is filed on 3rd of May 2024, wherein the notification by which the town vending committee has been constituted, notification dated 3/11/2023, by which the town vending committee has been constituted is placed on record. Stop. Stop. We have gone through the affidavit, and in the said affidavit, gone through the affidavit filed by the GMC, wherein it is mentioned that the town vending committee has identified 81 vending zones, wherein 6465 number of vendors can be placed in phase-wise manner. Full stop. It is further stated that the street vendors availing PM Svanidhi, PMSVANIDHI, this capital Majak loan are also included in the survey, and there is a proposal of giving them preference in relocation drive, subject to the approval by the town vending committee. Good stop. However, in the affidavit, the details about the 81 vending zones has not been provided. It is also not mentioned in the affidavit that when the phase one is going to start and what facilities have been provided by GMC as well as the GMDA, Guwahati Municipal Development Authority, Metropolitan Development Authority.
In those vending zones.
In those vending zones for the street vendors as well as the public at large, which is supposed to come to those vending zones. Stop. Mr. P. Nayak raised some time to file a detailed affidavit on the above aspects. 2 weeks time is granted. Just after 2 weeks.
Item 6.
But in consonance with the earlier order, my lord, the missing autonomous council filed affidavit.
Missing autonomous council was supposed to file.
We have filed, your lordship. We have annexed the copy of the minutes of the meeting of the executive committee, your lordship. That is at page 42, your lordship. And in fact, your lordship, we were directed to annex this minute, your lordship. And if your lordship comes to page 45 of our affidavit, your lordship. This is the minutes of the 30th General Council meeting. Page 45, your lordship, serial number 3. Survey of
Just a
lords.
My lord, in para for page 40, para 5, my lord, of the affidavit. Council action no? Missing autonomous council action 1995. Political. They got here. 1994. They got telling us about some. Para 5 of the definitive page 40 kindly see, my lord. Para 5 page 40, my lord.
41,
40.
40, yeah,
Para 5.
yes.
That as per the said resolution, a survey of missing alleged to be identified BPL families economically intervention by MSC based on survey report is to be done. That survey yet to be done, my lord.
Now they have proposed something.
Proposed to do so, my lord.
Well, it's a meeting, in the meeting, they have taken various decisions.
My lord.
That serve the purpose. After the 2nd of January 2024, any other meeting?
Lordship, so far as the survey today morning, I have asked them, Your Lordship, they have surveys virtually completed, Your Lordship. They can provide me copy of the report, Your Lordship, within a week. That's what they have informed me.
Yeah. Learned Council appearing for the missing autonomous council and submitted that pursuant to the direction given by this court on 1/3/2024 and 19/4/2024. An affidavit is filed on behalf of the Principal Secretary of the Missing Autonomous Council, wherein it is mentioned that the Missing Autonomous Council in its meeting dated 2nd of January 2024 has taken decision for proper implementation of the various schemes. It is submitted that so far as regarding the survey of survey for identifying economically backward families is concerned, the same is almost complete, and the copy of the survey report will be provided before this court on the next date of hearing. So, having gone through the affidavit dated 17th July 2024 filed on behalf of the Missing Autonomous Council, we direct Mr. S. Thakur to submit the survey report conducted by the Missing Autonomous Council, and also to file an additional affidavit regarding the progress took place in respect of the resolutions taken by the Missing Autonomous Council in its meeting dated 2nd of January 2024. Just after 8 weeks.
Deeply.
Deeply obliged.
Progress that.
Item number 7.
Please, your lordship. Lordship, I beg apology because on the, before the Lavazima court, I could not appear. There was no representation on our part, lordship. But I have got,
Repeatedly, you were directed
yes, lordship.
to file this proper address of the respondent number 7.
Respondent, lordship may grant us 1 week time. We will ascertain the new address and we will file. We could not appear.
Still you have not ascertained.
Lordship, we did not appear before the Lavazima court due to.
Despite repeated orders passed by the Lauzima court, the consent for the petitioner has failed to obtain proper instruction regarding the present address of the respondent number 7. Which stop. Then counsel appearing for the petitioner praised last opportunity to do the needful. Stop. In the interest of justice, last opportunity is granted to the counsel for the petitioner to provide details regarding the present address of the respondent number 7. 1 week last opportunity is granted. In the interest of justice, 1 week last opportunity is granted to the counsel for the petitioner to provide details regarding the present address of the respondent number 7 or furnishing the same. Let notice be issued to the respondent number 7 returnable 4 weeks thereafter.
Deeply obliged.
Item 8.
May please, your lordship. Lordship,
Respondent number 1, who is the state is the respondent number 1?
elementary education, lordship. Private respondent is also there, lordship.
Who is appearing for the respondent number 1?
Number 6.
Respondent number 1 is the state. Secretary Government of Assam Department of School Education.
You can appear, lordship.
Which is respondent state. Respondent number 6, who is respondent number 6?
School managing committee, lordship. They did not appear, lordship.
The notice has not been served, madam.
Lordship, in the repetition, writ appeal notice was sent, lordship.
And what is this application about?
Application 2370, lordship, I have filed recently against an impugn order, lordship, provincializing the service of the private respondent, lordship. She was allowed to take, lordship, to work in
Pursuant
this.
to the order passed by the learned single judge.
Lordship, no, lordship, impugn order is page 45, annexure 5, lordship. Earlier, there was a stay in the provincialization order as the single judge has dismissed both the petition, lordship. In pursuance to that order, lordship, and another special order order was passed on 25th July 2024, lordship. In compliance of the Honorable Court's order dated 11/5/23, that is the order passed by learned single judge. Lordship, against the common order of dismissal, lordship, I have preferred 2 writ appeals, lordship.
Item number 13 is also there, Lordship.
Item number
13, Lordship. Writ appeal 202 and 201, Lordship. Challenging the common order, Lordship, as two writ petitions were disposed of by that common order, Lordship. And Lordship, both the appeals were admitted by this court, Lordship, on 7/6/2023.
But what to do about the respondent number 6?
Lordship, School Managing Committee.
So if you have not, the application is required to be served upon the.
Lordship, I have taken step, Lordship. They did
as
not
per the
appear,
office
Lordship.
report. The
But Lordship,
notice.
my humble prayer, your Lordship may kindly stay the present impugn order. And in
without-
this IA
without
also, your
hearing-
Lordship may
without
allow me
hearing
to
all
take
the parties, this can't be done.
Lordship, private respondent is present, Lordship.
Private respondent may be present.
Already there was an Lordship stay in the earlier writ petition, Lordship.
You argue the writ appeal.
Lordship,
Both the writ
please,
appeals, you argue the writ appeal, both the writ appeals will decide.
Lordship, for final disposal,
Yes.
Lordship. Already admitted, Lordship, but the
Whatever it may be, so it can't be, whether so admitted, it can't be decided.
Lordship,
Argue it out.
I have taken some grounds in the writ appeals, Lordship.
Come to the controversy, what is the controversy?
Page 15 of the writ appeal, Lordship, I have taken stated the grounds, Lordship.
Madam, first of all, please, at least surprise with the facts. What are the
Lordship,
facts of
the
the?
facts of the case is that, Lordship, the appellant was appointed as assistant teacher, Lordship, in the year 1997, and private respondent was appointed in the year 1991, Lordship. But as she was doing another job of Anganwadi helper, Lordship, she was degraded by the SLC to second assistant teacher, and the appellant was upgraded to first appellant teacher, Lordship, assistant teacher. Against that order, Lordship, the private respondent preferred and writ petition, Lordship, in the year 2013. That was disposed of directing to take decision by the Lordship District Redressal Forum, Lordship. And then, Lordship, another order was passed saying that the appellant's case cannot be considered as because, Lordship, the SLC has no authority to upgrade or degrade. And private respondent case cannot be considered as she was working into post, Lordship. That order I have challenged in the year 2015 by a writ petition, but private respondent did not challenge that order, Lordship. During pendency of 2015 writ petition, Lordship, her post was provincialized. Then I have challenged that provincialization order by 2016 filing another writ petition. In the writ petition, stay was granted, Lordship. She was not allowed to work, Lordship. And both the writ petitions were, Lordship, disposed of by the common order, Lordship. Though she has not, Lordship, objected to that order, Lordship, whether her post can be provincialized, Lordship. So both the writ petitions were disposed of by a common order saying that, Lordship, as 2011 Act is not there, Lordship, SLC has no authority to degrade, upgrade, and Lordship, as there was no interim prayer of the petitioner in 2015 writ petition, so her provincialization order is good, Lordship. That is not bad in the eye of law. On that ground, Lordship, both the writ petitions were disposed of. I have challenged both the writ petitions by two writ appeals, Lordship. One of the ground, Lordship, the order by which she was not allowed to be considered for provincialization, that was not challenged by the private respondent by filing any writ petition. It is still holding the field, Lordship. How her post can be provincialized, Lord?
Mr. Counsel, we are hearing it finally. You are ready?
single judge order is page
Just a
130.
Please now. First.
Education 2017 or there is a district redressal committee under the 2017 Act, right?
2010 Act was there, 2007.
10 Act, 11 Act is gone.
Because it was done with the 11 Act,
That is gone now.
that is gone,
So under the 2017 Act, there is a,
District Scrutiny Committee, Section 13, Lordship.
so that committee is competent to decide these matters.
Yes, Lordship, that is one of my ground, Lordship.
Let it be decided by the committee.
It's already been decided, it was already decided
By whom?
by the district level committee at that point of time,
That point of time, in fact, you have admitted that you are working as a Anganwadi teacher also. How can you work as an Anganwadi worker and as well as teacher?
Well, my case was that both of them in the same campus,
Whatever it was, campus, the duties are altogether different. Teacher and Anganwadi worker. How can you compare these posts?
These were ordinary services, under the Ventures Institution, I was serving, at the same time, as an Anganwadi, I was also giving voluntary service, Lordship, may kindly turn to page 96.
Please tell us, Anganwadi worker and teacher both are the same?
No, they're not the same,
They are not the same.
But then, I was discharging both this responsibility and honorary, voluntary, service, the provincial.
What is the record that you are providing services as a teacher also? What is the record?
Well, in the school, my lord, I was serving as a teacher. That is not in dispute, my lord.
Which class you were teaching? What you
Well, those disputes are not raised because the lordship and see, my lord, they degraded me, my lord, on the basis of some letter of the former managing committee, president, my lord. Lordship may kindly see, my lord, how I was degraded, my lord. Page 55.
What we were also thinking,
My lord.
regardless of who is found to be senior to whom,
My lord.
what purpose will be served now? You can't be provincialized like this.
No, I was provincialized, my lord. I'm already serving, my lord. I'm serving.
That's right. But so far as regarding this, the provincialization of your services or his claim for provincialization or whatever it may be,
My lord.
let it be decided by this committee under section 13.
Well, the new committee, my lord, will be, my lord, now deciding under the new act, my lord.
Yes.
Then the earlier provincialization has to go, my lord. It will be fresh service, my lord.
Already till that decision is taken by that committee, you continue as a whatever on the post, and ultimately what decision the committee will take.
No, my lord, now of course, my lord, things will be different. My lord. Now, my lord, things will be, my lord, the parameters have changed. Now it will be a question of subject, my lord. Earlier it was a subject of seniority. Now my lord, the entire considerations will change.
Your whatever it may be, at that time when these subjects were not there, you were entitled for provincialization or not, they'll consider it everything.
But then the difficulty perhaps is that since the earlier act is not there.
His statement may encourage dispute. That is not even admin section. Dispute of class members is taken care of the admin. Totally different.
Lordship, I have taken.
Accepted or not. This is not, that cannot be a clear.
Mr. Datta, there are some factual projections here, which we are of the view that probably it has not been correctly, the entire gamut of the matter has not been correctly dealt with by the learned single judge. Some functionary in the department needs to inquire into these facts. Why don't we ask the director to look into the matter and pass an order?
Well, that was what your lordship, that's up to your lordship, that lordship can always do that, my lord. Just, my lordship, may kindly turn to page 85 for once. My lord was asking the duties, my lord. One of the duties of the Anganwadi workers were also, my lord, that non-formal pre-education, my lord, that's been imparted, my lord, page 85.
That
So-
take into consideration, the director will take into consideration all these aspects.
My lord,
Refer the matter to the director
my lord.
to decide the dispute inter se seniority or whatever it may be and the provincialization of the private respondent.
My lord.
Afresh and thereafter pass a order within a time period.
Of course, my lordship, my lord, I can object to that, my lord, but then my submission would be, my lord, the issue has already been decided by the director, my lord. He is, my lord, because.
Where is the decision? You just tell us. Where is the decision?
My lord, the district level committee, my lord, recommended my name, my lord.
No. Where is the decision of learned single judge? Where the learned single judge has said, yes, it was rightly done.
Pardon, my lord?
Where the learned single judge has said that it was rightly done. Rather, the learned single judge has recorded your this submission
My lord.
that yes, she was working as an Anganwadi worker.
My lord. I'm not disputing that, my lord. I cannot. I was working as both Anganwadi, my lord. My case was that, my lord, I was discharging as Anganwadi from 6 to 9, and from 10 onwards, I was attending the school, my lord. My learned friend is the next, my lord, my attendance register, my lord. Shit, my lord. That shows, my lord, I had been, my lord, working in the school from 10 a.m., my lord. which is the duty of ours, the school. So, well, I went to my school regularly from 10 a.m., my lord. Before that, my lord, as a voluntary service, I was.
Regarding the finding of the learned single judge that you have been demoted without providing any opportunity, that's right. That's right. But so,
Lordship, Shokos
Well,
was
on the basis of
given,
one,
she
my lord,
replied, Lordship.
on the basis of one former president's letter, my lord, I was, my lord, degraded. Lordship will see that order, my lord, that resolution. The resolution is very strange, my lord. It says, because of the letter of the former president, my lord, Lordship will find that, my lord, page 55 of the, my lord, writ appeal number 201. That is a resolution of the managing committee, my lord. Resolution number 1, page 55. According to the last resolution, it is so and so. Since the majority members expressed their opinion to promote Ismail Ali Sheikh, therefore it is decided to promote him to the second assistant to first assistant teacher. As per the letter dated 14/12/11/2012, the former president. So they take into account all kinds of, my lord, recommendations from former presidents and all, my lord, and to, my lord, remove me from the first, degrade me, my lord. Then, my lord, in the second resolution, they decide, my lord, to give full power to delete my name from the post of first assistant teacher, my lord. Total violation of the principles of natural justice, my lord. It's totally unheard in law, my lord, that some, my lord, some on the basis of some reports, my lord, which were behind my back, my lord. They have, my lord, voluntarily, my lord, made me, degraded me, my lord, first of all, my lord. In fact, the district level scrutiny committee, my lord, comes to a finding, my lord, that the headmaster was misleading, my lord.
ये गलत है. Point is, effective examination. You take it
Lordship.
So we'll ask the Director Elementary Education to.
Lordship, may I point out only one thing, Lordship, page 63, that is the reply given by the private respondent after show cause to her, Lordship. It is not a case that she was not heard, Lordship. That is, that finding is also incorrect, Lordship. Lordship,
what is this page 55?
Lordship, kindly see page 63.
Accordingly, the last resolution seems majority member so they promote the Ismail Ali SK. Therefore, it was decided to promote it.
No,
What is
Lordship.
this?
Lordship, before that, on her reply
Simply
is
because majority of the members said promote him.
no, Lordship,
So promote him.
after considering her reply, Lordship, page 62, your Lordship,
What is
kindly
that
see.
reply?
Page 62 and 63, Lordship.
And on humanitarian ground, he was promoted on humanitarian ground.
No, Lordship, kindly see page 63, her reply, that is the last paragraph, that I have been working as.
Beside the degrade second assistant teacher on humanitarian ground, what are these humanitarian?
No, Lordship, after receiving reply of private respondent, that decision was taken.
Where is the discussion about his reply, her reply?
Lordship.
From this resolution, is there any reflected, any reflection is there that they have considered their reply?
No, Lordship, kindly see the her reply is dated
Whatever
20.
it may be, ma'am, her
Lordship.
reply may be her reply or not. From this resolution, whether we can assume that her reply was taken into consideration.
Lordship will kindly see that reply, Lordship. She herself admitted, page 63, Lordship. Para for your Lordship, kindly see that I have been working as an assistant teacher of the school as well as an Anganwadi helper because the post of Anganwadi helper was a purely temporary one and I received remuneration only for my service as Anganwadi helper. So yeah, she herself admitted that she is receiving remuneration, Lordship. And then, Lordship, she was receiving the financial assistance also, Lordship. That is in page 63. Her reply itself says, Lordship.
Yes,
Para 4, your Lordship, kindly see.
yes.
As an assistant teacher of the school, I received financial assistance from the government in May 2011. And thereafter, I voluntarily resigned from the post of Anganwadi helper on 27/6/2011.
Yes.
So she is admitting that she is receiving remuneration only for my service as Anganwadi helper. My learned friend is making wrong submission, Lordship. Honorary, this is not an honorary post, Lordship. In
First
her
one-
reply, she is admitting, Lordship. And her reply is dated 2011-2012. And meeting was on 22/11, Lordship.
Yes.
The first time, my lord, the
Maybe
financial
the
assistance given, I
language is
resigned, my
not
lord.
proper, but Lordship,
The
she was
moment the
given
resolution-
ample opportunity,
The
Lordship.
moment it was given, my lord, financial assistance, I resigned, my lord. But prior to that, my lord, I was working on an honorary basis, my lord. And my lord, in fact, my lord, the Anganwadi Child Development Project Officer in page 96 has said, my lord, it's a government voluntary service, my lord. He has also admitted that I was not receiving, my lord, it's an honorarium service, my lord.
And
matter
director
comes
has
upon for-
already issued, Lordship, the present order, Lordship, by which she is now doing her job, Lordship. So that
This
may
is,
kindly be stayed, Lordship, till the decision, Lordship.
Table number 201 of the code. 237 of the
Item number 13.
My lord, just one thing, my lord, if your lords are referring the matter to me back, my lord, I'll just make a small submission, my lord. If my case is considered, my lord, it has to be considered from 2011, my lord. And if her case is considered, my lord, then
She is not agreeable, it's not being remanded.
Nikhil. The writ of appeal number 201/2023 and 202 writ of appeals number 201/2023 and 202/2023 are filed being agreed with the order dated 11/5/2023 passed by the learned single judge in writ petition number 5209/2016 as well as writ petitions number writ petition number 1177/2015. Full stop. The learned single judge, after hearing, after taking into consideration the submissions made on behalf of the respective parties, has dismissed both the writ petition while observing that the action of the district the action of the Balashi LP School Managing Committee of demoting, degrading the private respondent as second assistant teacher and promoting the appellant as as first assistant teacher in its meeting dated 22/11/2012 is without any jurisdiction, and that too without providing any opportunity of hearing to the private respondent. The learned single judge has also taken note of the fact that, as a matter of fact, in the writ petition number 1177/2015, the petitioner, the appellant, has not challenged, has not prayed any interim relief to restrain the authorities in elementary education department from dealing with the claim of the private respondent for provincialization. Full stop. The learned single judge has opined that the challenge laid by the appellant to the provincialization of the private respondent, but to the provincialization of the private respondent is without any merit. Having gone through the material available on record and after going through the impugned judgment, we are of the opinion that the prayer of the appellant through IA number 2373/2024 in writ appeal number 202/2023 for staying the operation of the order dated 25/7/2024.
Yes, Lord.
25/7/2024, comma, whereby the respondents have withdrawn the order, the earlier order whereby the provincialization of the respondent, private respondent was kept in abeyance, is not liable to be interfered with at this stage. Hence, the IA number so and so is dismissed. The matter is already, the writ appeals are already admitted and therefore be listed for hearing in due course.
Lordship,
Two IAs, one another IA and the other same.
no, Lordship, earlier I have filed 2 stay petitions, Lordship. Already your Lordship issues notice in both the issue and stay petitions, Lordship. And there is a direction to be decided by the special bench. Thereafter, the matters.
The other IA is also.
The Lordship is remanding the matter
IA
to the
number
director. I am agreeable to that, Lordship.
You have missed the chance.
In
That
writ
was
No,
appeal
Lordship,
number
I was,
201
I am only saying that he is
2023
making wrong
is
submission,
also
Lordship.
disposed of, है ना? Yes.
Obliged. Yeah.
Item number 9.
Yes, state has finally response.
Probably, my lord, after implement, notices will not been issued,
Notices have not
not
been
been issued. Issued was done. Okay. No, no. Main case.
issue notice.
Yes, I provided.
Issue notice of the
Comment.
Mr. Who are appearing for the respondents, all the respondents are.
I am for the only one, my lord, High Court, my lord.
Mr. Mehta, put in appearance on behalf of the respondent number 1.
Only one, my lord.
Madam. And what about this earlier RB Bora, learned advocate Assam appearing for 226? And you are appearing 327, learned AAG Nagaland. Yes. 327 A Chandran, additional PV, senior PP, Arunachal Pradesh. All the respondents are represented, 2 to 6. 2 and 6, who is appearing for government of Assam?
Sorry.
25/6/2024. It's on the sheet में लिखा हुआ है, who is appearing for issue notice. Mr. So-and-so, 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 accept notice on behalf of, except on behalf of the respondents. Copy of the writ petition be supplied to the respective counsels for the respondent within a period of 1 week. The counsel for the respondents may file counter to the writ petition within 6 weeks. List this appeal after 8 weeks. This writ petition, PIL petition after 8 weeks while reflecting the name of the respective counsels in the cause list.
Highly obliged.
Item 10,
May I please, Your Lordship? So far as respond number 2 and 3 is concerned, I am also aiming for this respond number 2 and 3.
Respondent number,
2 and 3.
and what about the respondent number 1?
1 already I have filed 1 and 4
1 and 4.
So you are appearing
for all the respondents.
All the
all
respondents.
respondents,
All the
1 to 4.
1 to 4.
Okay, Mr. So-and-so put in appearance on behalf of all the respondents. Services therefore complete. List this writ appeal for admission after 4 weeks.
Right.
item 11,
There is an office note regarding service on respond number 5, my lord. We have taken steps in the month of June, my lord.
So
Can we serve a copy by email, my lord? That address is
an
available.
additional affidavit filed on behalf of the appellant.
But we have filed, my lord.
What additional affidavit you have filed?
Bringing on records, my lord, the subsequent developments.
What subsequent?
Because the tender was allotted in the meantime, my lord. The work was awarded, my lord.
And to that authority, you're seeking impleadment of that authority.
That
too.
authority has already been implemented, my lord.
And what happened, whether the notices have been served? upon?
Notice has not been served, my lord, on respond number 5.
So that is the authority to whom the fresh tender is
Yes,
granted.
my lord. The work has been awarded.
And take fresh steps for that.
All right, my lord. Can we serve also a notice by email, my lord?
You just first try to do it. Okay. The notice of the respondent number 5 has not been served till date. Stop. Learned concept for the petitioner is directed to take steps for issuing fresh notice to the respondent number 5 through registered AD as well as listing. Within a period of 1 week. On taking such steps, let notice be issued to the respondent number 5 returnable 3 weeks thereafter.
item 12,
Fresh matter,
May it please your lordship, it's a condemnation of delay matter, your lordship. Kindly may delay be condoned.
yes, you are appealing for
For respondent 3 to 6,
3 to 6.
Lordship.
The notice has to go to others.
Yes, my lord. 1 and 2.
Issue notice. Mr. So-and-so, accept notice on behalf of the respondent number 3 to 6. Let notice be issued to the other respondents returnable 6 weeks thereafter. Returnable 6 weeks.
for admission, item 16,
My lord, the case of the petitioner was for a claim for regularization for the post of paper. My lord, our case before the honorable single judge was that I'm for the might of the Indian Oil Corporation.
Delay.
Yes, my lord. That is the only point because my lord, the earlier it has been decided in a similarly situated my lord person's case. But then this petitioner has come after 22 years. He was a fence cheater, my lord. And
If the similarly situated persons were granted that relief only in the year 2018, not much delay.
my lord, he approached this court after 22 years.
After all,
On
he's
that,
a
my lord-
low-paid employee was wrong.
My lord, on that, my lord, I placed 2 decisions of the Honorable Supreme Court. And
That learned single judge has taken into consideration.
yes,
also
my lord,
this.
he has rejected saying that, my lord, this is a continued wrong.
That's right. But since all the persons pursuant to this notification dated 7/4/1995, services of all those persons have been regularized, why to penalize this person? After all, he is a poor person. He has not
That's-
approached the
your
court.
lordship
That's
is
not,
right.
it's like a highly educated person and deliberately has not approached the court. Maybe there are so many reasons.
Yes, it's 22 years of delay, my lord.
Whatever.
I leave it to your lord.
This-
Only my lord, those two resistance. Discuss policy to do that.
This writ appeal is preferred by the appellant being agreed with the order dated judgment dated 24/11/2023, passed in writ appeal, writ petition number 3651/2019. So the private respondent has approached the writ court by filing the aforesaid writ petition with the prayer to issue a direction to the respondents to regularize the services of him on the ground that the services of the similarly situated persons have already been regularized. Stop. The learned single judges allowed the writ petition by the impugned judgment while relying on the decision of the division bench of this court rendered, while relying on the judgment dated 6/6/2018 passed by the division bench of this court in writ appeal number 56/2018, wherein this court, the division bench has ruled that the action of the respondents of denying regularization of services to the persons, to the employees who are working on who are working since long, who are working from years pursuant to the notification dated 7/4/1995 is discriminatory, particularly when when the services of the similarly situated persons have already been regularized. Stop. The only objection raised by the appellants before the learned single judge was to the effect that the private respondent has approached the writ court with a delay of around 22 years. Full stop. The learned single judge, having considered the said objection of the appellants, and after taking into consideration the various pronouncements of the Honorable Supreme Court, has
Which were relied by me.
rejected the said objection of the respondents, the appellants, having gone through the findings of the learned single judge and taking into consideration the overall facts and circumstances of the case, we don't find any case for interference. Hence, this is appeal. This.
Item 18 to 20.
Maybe the loss. While relying on, why am I line while relying on the decision of the division bench in so and so so and so. It is after going through the material available on record, we are of the view that the private respondent stands on the equal footing of the persons, of those persons, of those persons of those. Equal voting to those persons to whom, to those persons to whom the relief was granted by the division. By the division. And there is no valid reason for the for the appellants to discriminate with the private respondent. Yes.
Maybe the loss. So in this matter, the challenge herein is particularly regarding an order of regularization that has been
The
directed. by the-
last occasion,
Yes, Lord.
we raised some query. We
Yes, Lord.
have that
So
document.
my predicament today is some instructions have come,
Yeah.
but the total instructions regarding the fate of those employees from the erstwhile company to this new company is
We
without.
simply raised a query
Yes, Lord.
that this Hindustan fertilizer at the time of taking or of the this HFCL by this PVFCL, the liability of the school run by the SFCL was not fastened upon the appellant. That's you just show us.
Yes, that document I've not been able to gather. I just need a few days' time. That is, some documents have come, but
Take care of it. Run a concept with the appellant.
item number 19, Lord.
Appellant, raise some more time to satisfy the query raised by this court on 17/7/2024. How much time? 4 weeks. Just
Yes,
after
sir.
4 weeks.
Of light loss.
I mean, the other two have signed the appellant file.
Yeah,
Item number 16 and.
the same query is with the same query is.
Instructions.
Complete your instructions and come.
Oblige, Lord.
Item 21.
Yes.
Lordship, this is regarding competition appointment, Lordship. Lordship, Lanesh Singhal just had said that my claim, there is no force on my claim, Lordship, competition appointment, Lordship. Lordship, Lanesh Singhal has relied upon the judgment of the Devabrata Tiwari, Lordship. Lordship, subsequent to the judgment, Lordship, Honorable Supreme Court has considered that delay part, Lordship. In Govinda Janardhan Gaikar, Lordship.
Yeah. Yes.
Lordship, paragraph 6.
Paragraph. Yes,
Lordship, my case was rejected on the ground of there is no vacancy.
vacancy here.
Yes, Lordship, by the OM of 1/6/2015, Lordship, there's a provision.
Yes,
Lordship, there is a provision as per clause 15, Lordship, even if in at page 45, Lordship, if sufficient vacancies are not available in any particular office to accommodate the persons
this
in the
clause
15, Lordship,
1.15 of which
of the OM of 1/6/2015, Lordship.
2015.
Yes, Lordship.
And this scheme of providing compassionate appointment still is in currency.
It is not in currency, Lordship.
So if it is not in currency, how can we issue a direction to provide appointment?
Lordship, if someone dies after 2017, then under the new schemes is new scheme, the government is the compassionate family pension is there, Lordship. But before who died 17, then there will be.
So the person who died before 17 and his dependents can at any point of time come to the court and say "Okay, even after 25 years, then it is applicable.
No,
Even
Lordship,
after 25 years, they can approach the court. Why you approach so early?
Lordship, I filed my appointment, my application on time, Lordship.
Which time? That was rejected. At that time, you have not challenged that. That your application was rejected when?
Earlier 14, Lordship.
But 2014.
Yes,
Your application itself was rejected in the year 2014.
yes, Lordship.
And you have not challenged that decision till 2024.
No, Lordship, the later on they have again placed my application on 2022, Lordship.
2022.
Yes, Lordship.
Under which provision, sir? 2022, how can they again place your record? When the scheme itself. When the
At
scheme
page
itself
35,
was
Lordship.
withdrawn?
At page 35, Lordship.
35. This must be on your application, some 35, yes.
Along with me, Lordship, there are other applications also considered, Lordship, by the district
Where is
DLC,
your
Lordship.
discussion?
Discussion at page 37, Lordship.
37 serial number?
6, Lordship.
6. Late so and so the proposal, so and so executive. But as per the report, executive engineer, no vacancy available, proposed, he was already rejected on so and so on the ground that better financial, on the ground of better financial position. Hence, the engineer rejected on the ground of non-availability on the basis of so and so, so and so. That's what's wrong in that. Your application was rejected in the year 2022. Again, you applied. Then they said, this can't be taken into consideration. That's all.
Lordship, as per provision 15, if there is no vacancy, they have rejected my claim on only on the vacancy point, Lordship.
Fine.
If that vacancy is not there in the department, they can very well consider my case by the other department, Lordship. I'm on that point, Lordship, and by this judgment, Lordship, the Honorable Supreme Court has clearly said that if I have survived for 15 years also.
Yeah.
In my case, Lani Singhal just said that I have survived 11 years.
So which judgment we have to follow? The learned single judge has relied upon another Supreme Court judgment which says that it is not a vested right and it always the time of death or or giving appointment has to be taken into consideration.
Lordship,
The Supreme Court has said since compassionate appointment is not a vested right and the same is relative to the financial condition and hardship faced by the dependents of the deceased government servant, as a consequence, a claim for compassionate appointment may not be entertained after lapse of considerable period of time since the death of the government employee. So which judgment we have to follow?
Lordship, that judgment came on 3rd of March 2023. And this subsequent judgment came on.
This judgment was the earlier judgment was taken into consideration by this court in this judgment.
No, Lordship, but the provision court has said that if the welfare, because in a compassionate appointment, Lordship, it comes from the welfare state.
We are not supposed to get comment on it, but sorry, sir. Again, this writ appeal is filed by the appellant being agreed with the order dated 5/6/2024 passed by the learned single judge in writ petition number 2906/2024. Full stop. The appellant has approached the writ court with a prayer to direct the respondents to provide him appointment on compassionate ground as per the OM number, as per the principle 10 of the OA number 16/2015, read with subparagraph 10 of 2015. Full stop. The learned single judge has dismissed the said petition while relying on the decision of the Honorable Supreme Court rendered in State of West Bengal versus Devbat Trivedi, wherein it is categorically held that that compassionate appointment is not a vested right and the same is relative to the financial condition and hardship faced by the dependents of the deceased government employee as a consequence of his death, a claim for compassionate appointment may not be entertained after a lapse of considerable period of time since the death of the government employee. Learned single judge has taken into consideration that the father of the appellant died in harness while in government job on 1/8/2013. Full stop. Learned counsel for the petitioner has submitted that recently the Honorable Supreme Court in Govind Janardhan Gaikwad versus State of Maharashtra and another reported in 2023 0 Supreme SC 1273 has held that the action of the respondent in those cases of rejecting the claim of the appellant for compassionate appointment on the ground of delay is not tenable. Stop. Learned counsel relying on the said judgment has submitted that the learned single judge ought to have issued a direction to the respondents to consider the case of the appellant for providing appointment on compassionate ground, ignoring the delay, ignoring the fact that the father of the appellant died way back in the year 2013. Stop. Having heard the learned counsel for the petitioner, appellant, and after going through the material available on record, particularly taking into consideration the fact that initially the claim of the appellant for compassionate appointment was rejected way back, rejected on 26/6/2014. However, thereafter, the appellant has not challenged the said decision and instead has filed another application for seeking compassionate appointment before the district level committee in the year 2022. Full stop. The said application of the appellant again rejected by the district level committee in its meeting on 21/2/2022 and challenging the same, the petitioner has preferred writ petition in the year 2024. Full stop. It is also to be noticed that the scheme of providing compassionate appointment to the dependents of the deceased government employee has already been discontinued in the state of Assam since 1/4/2017. Taking into consideration the above facts and circumstances of the case, we are of the view that no case for interference is made out, hence petition is dismissed. Appeal is dismissed.
Lordship, only one point that I did not apply for second time. The DLC has considered my earlier application. That was
The did not apply, but the case of the appellant was again considered by the DLC.
Item 23.
Yeah.
Next, Your Lordship, my lord, challenge before your lordship the constitutional validity of subsection 4 of section 16, as well as the order passed under section 73 that your lordship will find at page 35.
That, I think so, that
My
is
lord.
already pending before the.
Pending, my lord. But my lord, in addition to that, my lord, the order passed under section 73 is barred by limitation as per section 10 of section.
Either you can, you challenge the validity of or that.
Both,
you
my lord,
challenge
if
the-
I succeed in not succeed, then my lord, that point will come.
That can't be, you can't have both the things in your hand. Yeah, issue notice, returnable.
Deep.
Item 24.
Lordship. Lordship, in this case, there is a mistake. Lordship, there is a mistake on our part. The order impugned before the tribunal that has not been annexed. Let me bring that through an affidavit, Lordship.
That has not been dated
16/4/18, Lordship.
16/4/18.
Lordship.
So you have annexed some 23 orders.
Lordship.
This annexure. Arjan. At the request of Mr. B, security list this matter after 3 weeks.
Item 25.
There are other matters pending. There is a series of PIL pending on solid waste disposal, is it not? Mr.
Yes, ma'am.
Yes. Any detail?
Probably,
Yes, any detail of that? I'll list along with this. Issue notice, returnable, 8 weeks.
Item 27.
Maybe the lordship. One of the appellant before lordship. He was the academic registrar of Guwahati University. Then, my lord, on being selected by Bhattacharya University for the post of registrar, he joined that post on lien for a period of 2 years. Then, my lord, during that period, there is some criminal case. And eventually, my lord, he has been released, my lord, relieved from that, my lord.
Post of registrar.
Post of registrar. Now, my lord, the issue that falls for consideration is about, my lord, interpretation of 2 clauses of the first statute of Bhattacharya University. That your lordship will find, my lord, that has been quoted in the judgment itself.
The, just a minute, just. This interpretation of these clauses is required looking to the fact that you were on this probation, working as a registrar in the university, and you got red-handed while taking bribe of rupees 50,000.
That is an allegation.
The red court is required to be considered. That is the allegation, and against which still you have not been discharged from that allegation.
Not yet.
That is there.
Yes.
So why should the red court should go into
No,
all
my
this interpretation and
no,
all, looking to your conduct itself?
No, my lord, the order has to be
You
passed.
got red-handed, you were arrested, later on you were released on bail.
I was trapped, my lord. I was trapped, that is my case.
Got red-handed, trapped, okay, trapped, it's a
No, my lord, the question, my lord, the question that falls for consideration, my lord, there are 2. Firstly, my lord, that interpretation of those 2 clauses under which, my lord, I have been discharged, and the other thing, my lord, can I, my lord, borrowing department?
Probation is only for the purpose of to test the person whether he is suitable for that post or not. And in looking to these incidents, if they found that you are not suitable to hold this post, what's wrong with that?
My lord, my submission before lordship is that, firstly, my lord, can a borrowing authority take any action against the, my lord, person except releasing him and sending him back? He was placed under suspension. When that
you are not challenged that suspension.
No, my lord, that is not here, but in the meantime, my lord, he has
suspension order you have not challenged.
No, not.
Then
yeah.
what remains that?
Now,
That
my
part
lord,
is over. Now you have been relieved.
I have been released, my lord, and my lord, that is in exercise of power of the first statute. You have that interpretation, my lord. Your lordship, I had pointed out that.
Any case.
So there has to be an inquiry, my lord.
You are on.
If the power you have.
Probation for a period of 1 year.
My lord.
That period is over.
No, that period is yet to be over. He joined on, my lord, 6/5/2022.
6.
And my lord, he was released on 31/1/2022.
6/5/2022.
Yes. And he was.
So that now 24 is there. 2 years have already passed.
Yes, but when the order was passed.
We can't ask them to again retain you in the service. Retain you on this post of registrar.
My submission before lordship, my lord, will be whether, my lord, they have exercised the power which has been given to them under the statute. Because, my lord, there are 2 clauses.
That period has already been over. Now what remains? We can't direct them to again appoint you registrar.
No, my lord, the legality of that order, my lord, I am assailing the legality of that order because, my lord, the 2 clauses are, my lord, a little different.
Issue notice, returnable so and so accept notice on behalf of.
My lord, I am appealing for response number 3, 4, and 5. What about 1, 2, 3? My lord, just one submission if you lock with permission. My lord, pursuant to the release order, he filed a writ petition which has been dismissed. And he has gone back to his parent department and joined there, my lord.
But still he is insisting what we can do. We can't issue notice. So and so appealing on so and so, issue notice to the, accept notice, issue notice to the remaining respondents, returnable 8 weeks.
3, 4, and 5.
Response number 1 and 2, state of Assam, director.
Yes, I'll take steps, my.
I am for 3, 4, and 5.
Make a mention before the court master.
Item 28.
Obliged. May I please, your doctor?
Happened to here. It's 68.
Yes.
My lord, the case relates to the Manipur violence, my lord.
Yeah.
The petitioner, he was arrested in one of the cases that happened in Manipur, my lord. Therefore, what happened, my lord, the government of Manipur, they have transferred the case to CBI. And subsequently, on the direction of the Supreme Court, 27 number of cases were transferred to Assam, my lord. And day-to-day trial is being held in Assam, in the CBI court.
Where is that order?
Order is at Annexure 6, page 67, my lord. Relevant page is 71, my lord.
But we are conscious of the situations of page 72.
Yes, my lord.
Page 72.
Yes, my lord.
So where is the, these directions?
Yes,
Nowhere says that only up to this, we request the chief, I go to chief judicial magistrate and session judge and so and so. He'll conduct all these cases. But only by these directions, sir, we have already sought clarification from the Honorable Supreme Court also. You please we advise you, please get a clarification from the Honorable Supreme Court. We'll certainly entertain this until and unless the position is clarified by the Honorable Supreme Court. You would not be able to take this.
No, my lord, already they have filed their search sheet here in Guwahati, my lord.
They have filed?
CBI has filed a search sheet, my lord.
Yeah, charge sheet, that we understand.
Yes, my lord.
Only simply because the cases were transferred, the Guwahati High Court would have the jurisdiction.
In that order, there is nothing has been mentioned.
Mr. Rashid, what you are saying may be a logical.
Yes, my lord, because already search
But
sheet is.
that will not be sufficient for this court to, because the Supreme
Excise
Court.
jurisdiction, sir.
No, already they have issued.
In fact, this matter came up before me on the administrative side. But looking to this difficulty, though we have attempted to get a clarification from the Honorable Supreme Court, but we have not.
That is
received any
pending.
clarification.
That is the order, my lord, first, that is still pending.
That is pending.
Pending,
We
my
have
lord.
already
And
approached
report has
the-
been called from the state of Manipur, man. That is the order, man. We have also, because we have no even, the trial court has, my lord, CBI, my lord, special court. Guwahati has also, my lord, whether they will proceed further, my lord. From the,
That's the whole thing. The
so
problem is here.
that's why clarification sought from my lord, there's lighted letter to the High Court and High Court send it to the, my lord, Supreme Court, that is in administrative, now, my lord, in judicial side, my lord, they have taken up, my lord. That is also pending. So in that case, my lord, how can I, my lord, entertain bail application, my lord?
That's the whole thing. We don't have any problem in entertaining. We have several bail applications we are entertaining, but in this time, we'll certainly entertain that.
Yes, my lord.
Unless there is a clarification.
But
That's the whole predicament.
My instruction is that already trial court has issued summons to the accused persons, my lord, but appearance is not yet complete. If the trial court is proceeding with the trial, my lord, then obviously the accused right cannot be curtailed.
Trial court is proceeding because of the Supreme Court order,
Yes, my lord.
not because of the erstwhile CRPC. You have to understand this.
Yes, sir.
Your right to approach this court is because of the CRPC. But CRPC, as it was existing then, that may not come into play here because the Supreme Court has directed the trial court to take everything.
Yes, my lord.
Get a clarification.
Let a clarification. You also apply for that clarification. The things would be
You
clarified.
can refer to this matter also.
File your reply, state. Statement file there.
Leave them, okay?
Issue notice, Mr. Mehta, accept notice on behalf of
Respondent.
all the respondents are represented. You mark the attendance of all the respondents, written, so and so accept notice on behalf of the state, on behalf of all those respondents.
I am for two to
Just
five.
after 4 weeks.
Awesome.
Item 29.
May it please the Lordship, Lord. Lordship, in this case, the respondent was departmentally prosecuted, Lordship, for failing to perform his part and dereliction of duty for which there was a fraudulent withdrawal of 5,37,000. Now, Lordship, the tribunal held that there was a delay on the ground of delay and no order, nothing was stated as on fixing responsibility upon the respondent as the how that was caused. And as per his explanation, it is the duty of the Lordship may kindly
Notice. Reasonable. 8 weeks. That's the. Registered ADM.
oblige.
Yes.
Item 30 and 31.
May it please the Lordship.
Who is appearing?
Mr. Adil Ahmed had appeared, Lordship.
Password for the timing. The matter is not admitted till date.
Lordship.
Stay is already there.
Lordship. Three notices already.
Who is appearing?
I haven't seen him today, Lordship. I haven't seen him today. He's mostly in the CAT. Represented. The council is not present.
What learned concept of the petitioner? None is present on behalf of the respondent. Having heard the learned concept of the appellant, we deem it appropriate to admit the writ petition. Hence, admit no need to issue notice to the respondents as they are already represented through advocate. List for hearing in due course. Interim order is already made absolute. Made absolute. Yeah, it is already 30th of March.
Item 34.
Same order in 30-31.
31 both.
This is a writ appeal against the judgment passed by the learned single judge. Holding that the search and seizure is to be preceded by notice under section 131. That is not the scheme of the Income Tax Act, Lordship.
That is
not the scheme of the Act, Lordship. Search and seizure is independent to section 131 notice, Lordship. But the learned single judge has page 253, Lordship. Paragraph 52. Thus, both the essential conditions have not been fulfilled in the facts of the instant case before conducting search and seizure on 4/12/2020. Non-fulfillment of the same has been rendered search and seizure illegal and without jurisdiction. Lordship, page 230, paragraph 12. The argument of the learned counsel for the writ petitioner was confined to issuance of 131 only. Interim के लिए है, whether they will find it.
This notice under section 131(1)(a) was issued after the search.
Yes, sir. It was issued after search. And there is no judgment of Supreme Court on this point. However, different High Court says, Allahabad High Court in two judgments says that it can be issued after search and seizure also. But different High Court says, in some High Court says that no, cannot be issued. Examine the matter, notice they were here.
Notices, you are appearing for all the respondents?
Only sole respondent.
I am appearing for
All respondents.
Yes, sir, sole.
Mr. Lordship, kindly see that section 131(1)(a) is very clear. It says prior to the search and seizure, the 131(1) can be issued. No,
Not after that.
not after your Lordship see the that prior to
Consider it, sir. Issuing notices simply, nothing else. Where
Notice has already been issued, Lord.
Mr. Dr. A. Saraf put an appearance on behalf of the sole respondent. Service is therefore complete. Admit will admit it.
Admit and Lordship, interim stay, Lordship.
the stay, I have the submissions before your Lordship.
Stay.
Lordship, because Lordship, it cannot be preceded by notice, Lordship.
And this is a wide ramification.
A single judge has never said that it must be preceded by the 131 notice. None a single judge says that the issuance of notice after such a seizure so goes to show that you'll also see the paragraph 51. My learned friend read it, but not read fully. The Lordship will just see 51.
Mr. Kail, what will happen if a stay is granted? What will you do?
No, Lordship, because our
Just answer the question.
such
first.
and seizure.
What will you do if a stay is granted?
No, Lordship, in this case, in case of petitioner, Lordship, probably we may.
What will you do if a stay is granted?
Because Lordship, single judge said that the search and seizure has become illegal if the notice is issued, Lord.
But we allow you to proceed further, and what would remain this of this order?
No, Lordship,
The learned single judge, whatever the order passed by the learned single judge will be redundant. How can we allow you to proceed further until
no,
it must
Lordship,
be decided?
Lordship may provide that with respect to petitioner will not take any courtship action.
So, but then against whom you will take the course
No,
of
Lordship,
action?
other such as seizure, Lordship.
Other searches is not a judgment in rem.
Lordship,
This is a judgment in a particular case. It's not judgment in rem.
the Lordship may provide this, Lordship, otherwise because
Where is the question of providing it? Where is the direction of the learned single judge that in all the cases where such thing has happened, you can't proceed?
although it is not provided,
Then,
Lordship,
nothing.
Lordship may please to come to paragraph 12, page 230, Lordship.
Really,
What was the case before the learned single judge of the petitioner?
here itself, that's why only today they have come here. Mr. Dr. Esara put in appearance on behalf of the sole respondent. Service is therefore complete. Would you like to file some counter on? There is no, I don't think that it is required. The service is therefore complete. Is this matter for final hearing in the month of October at admission stage?
Lordship, regarding my interim, some observation been made.
However, looking to the facts and circumstances of the case, particularly the fact that the learned single judge has set aside the notice issued under section 131 in bracket 1 capital A of the Income Tax Act. We don't find any case for grant of interim stay on the judgment of the learned single judge. And learned single judge allowing the respondents to proceed with the notice which is set aside.
Lordship, paragraph 54 can may kindly be seen.
Hence this
54 page 23. Lord.
IA is dismissed.
Lordship, the entire operation has been set aside. Lord.
Entire?
Authorization, page paragraph 54. Lordship, for my satisfaction, Lordship, please go to paragraph 54.
The problem is, Mr. Kayan, this, your satisfaction will not work.
No, Lordship.
Satisfaction is the court is required here.
No, Lordship,
Yes.
I'm not done. Just for Lordship, please peruse paragraph 53.
Yeah.
54.
It isn't really issue of authorization.
Dated so and so, consequence such and seizure conducted so and so, and notice dated so and so. Under
Yeah.
section 138 are satisfied in court.
So that's why.
So entire search and seizure has been, it cannot be preceded by any notice. Lordship. It is independent and honorable Supreme Court in case of
We'll consider. Sir.
Kalzivai Kanzivai.
Yes.
Stay the case for revive नहीं कर सकते.
Item 35.
This Sumoto PIL was initially registered pursuant to an incident of mob lynching in Arunachal Pradesh, Teju. And thereafter, criminal investigation cases were registered and investigation was done, charge sheet filed in that case. And at the time of framing of the charges, all the 6 accused were discharged. Then, the state filed criminal petition before the Honorable High Court, and that is pending. In the meantime, this scope of the PIL was expanded And my lord, installation of CCTV camera and my lord, integration of data with the jail authorities, those are considered. Now, those things are, my lord, already CC TNS scheme regarding integration of data and other things, those are already covered. Only issue remains is that the criminal petition is pending before the Honorable High Court Itanagar bench.
That is already.
Now, what I have seen checking the records that the respondents, that the accused persons, they are not repeatedly appearing. So it can be disposed of subject to what your lordship says, that directing the state to expedite that proceeding. Because
Action under the law initiated. Purpose of this thing.
Yes. Okay. This PIL petition, this suo motu PIL petition was registered taking notice of an incident of mob lynching took place in February 2018 in Teju, Arunachal Pradesh, wherein a mob of around 800 people attacked the Teju police station and dragged out two suspects from the lockup and beat them to death. Full stop. It is informed by learned amicus curiae that the police has arrested 6 accused persons in relation to the said incident, and later on they were also charge sheeted, but the trial court has discharged all of them, against which the state has already preferred an criminal writ petition.
criminal petition number 118.
Revision.
No, criminal petition.
Criminal petition before the before the High Court, and the same is pending consideration. It is noticed that during the pendency of this writ petition, wide order dated during the pendency of this petition, this court wide order dated 15/5/2023 has expanded the scope of this PIL petition, suo motu PIL petition. By passing the following order, 15/5/2023, this order may be quoted. Stop. After passing of the order dated 15/5/2023, this court has issued various further directions to the state of Arunachal Pradesh as well as the state of Assam. And pursuant to that, several required steps have been taken by the state of Assam and the state of Arunachal Pradesh, and the reports of the same has been submitted before this court, and the same has been taken note of by this court in the various orders passed by this court. Learned Counsel, Mr. Das, amicus curiae, has submitted that the required steps as per the direction has been taken, already been taken by the state of Assam and state of Arunachal Pradesh. And the Arunachal Pradesh, it is also submitted that since the criminal proceedings regarding the incident for which this suo motu PIL is registered is pending adjudication before pending adjudication, no further order is required to be passed in this suo motu PIL petition. In view of the submission made by the learned counsel, the amicus curiae, this PIL petition is closed.
But Mizoram is and Nagaland is also there.
Mizoram and Nagaland is
Yes,
also there.
apart from
They have also
Assam.
submitted their.
Yes, they have also submitted
Java
affidavit.
states का करते हैं. Yes.
Petitioner challenged the order of CAT, what is there? Petitioner number 1 is the second wife of the deceased railway employee, and the petition number 2 is a minor son. After the death of the deceased railway employee, petitioner number 1 submitted a representation for claiming her family pension. That was not decided by the railway authority. So both of the petitioners had approached the Honorable Tribunal, and the Rana Tribunal, without dealing anything on the railway rule or the right and entitlement of the petitioner number 2, has dismissed the original application. My lord, it is the stand of the railway respondents authority is that, my lord, there in terms of all the documents submitted by the deceased employee, there is no nomination of regarding the name of the petitioner number 1 and 2. So but they have not denied anything on the legality, on the merits of the.
What about the first wife?
My lord,
What is the stand of that first wife?
first wife stand is the respondent number 5 admitted that she is the second wife, the petitioner number, in the written statement before the railway. And with regard to the son, they have not said anything. Now, my lord, I am relying on the law laid by the Honorable Supreme Court in the case of the Rameshwari Devi, and I have enclosed here also. So, my lord, the legitimate or illegitimate has the right to pension.
How your marriage is recognized once the first wife is already there? How you can be treated as a second wife?
My lord, he has married the petitioner number one.
How that marriage
And that is, my lord, that is what, my lord, that is voidable marriage. And for that, my lord, I have relied on the Honorable Supreme Court judgment on the Rameshwari Devi. Same situation, my lord, dealt by the Honorable Supreme Court. And in a case that there is also, my lord, there is also an inquiry by the direction of the single judge of the Patna High Court. And thereafter, by the inquiry, thereafter they have held that there is and right in the para 14, page 117. At the law like that.
What is the stand of that this first wife? Where is that?
First wife is, my lord, the written statement they have submitted at page 93, para 9 of the written statement. 93. 90. Para 9, 93. That the statement made
Just a minute.
Yeah.
So I have mentioned it. So I have mentioned it.
Thank you.
What is wrong with the judgment of the CAT?
They have not felt anything with regard to the claim of the petitioner number.
Where she has admitted this first wife that you are the second wife? Where she has admitted?
Page 90.
Her stand is that the deponent is the only legally married wife of Amal Sakia.
My lord, that the state para 9, page 93. That
Para 9.
Para 9. That the state page 93.
Yeah.
That the statement made in paragraph 4.5 of the word deponent denies the same in the context the deponent back to state. Admittedly, the applicant being the second wife got married with Amal Shikha during substance of the first wife with the deponent. As such, the marriage with the applicant itself is void. And
if she said yes, second wife, how can we? So her admission is enough to declare your marriage.
My lord, my humble submission, it is admittedly she is not married. Then, my lord, the right of the
she is admittedly not married. Then certainly
that marriage is void.
Then certainly she can't be treated as a second
That marriage is void. That I admit. That marriage of the petitioner number one, that is a void marriage. Then, my lord, I am coming to the right and entitlement of the minor son of the deceased employee. Then he was also the applicant before the tribunal. That is what, my lord, I am relying on the judgment of the court. That, my lord, page, I am relying in this judgment of the Honorable Supreme Court in the case of Rameshwari, the state of Bihar and others.
Yeah, what it says?
My lord, page 114, para 9.
Is that judgment, copy of that judgment?
My lord.
Copy of that judgment?
Yes, my lord. There is, here is, my lord, in the part of the read petition. Page 110.
Rameshwara Devi, the Supreme Court has only said that children born out of a voidable marriage would have a right. But that right has to be asserted in the civil court.
My lord, before the, my lord, I am reading on paragraph. I am reading on paragraph. 100, page 114, para 9 of this judgment. Now, when the first order was cancelled by the state government and the second passed by depriving the Jogamaya Devi and children of any right of the pensioner Narayan Lal, she filed writ petition of the High Court, which was noted above was allowed by the learned single judge and later filed by the Rameshwara Devi. Against that was dismissed by the division bench of the High Court, which is impugned. Learned single judge referred to the section 16 of the Hindu Marriage Act 1955, holding that even though the marriage of the Narayan Jogamaya Devi was void, their children would be legitimate and thus would be entitled to claim share in the family pension and death cum retirement gratuity of Narayan Lal, but only till the attained majority. Learned single judge accordingly issued direction to the state government to issue first sanction order for payment of the arrears of the family pension and death cum retirement gratuity to the minor children born from wedlock between women.
No need to issue notices, but it has already been presented. This for hearing in due course.
My lord, obliged.
Item 37.
My lord, victim compensation scheme, my lord, last occasion, my lord, there is a direction, my lord. There is no need change of the circle.
The meeting had taken place on 9th of August, Lordship. There was a deliberations amongst all the stakeholders. The Asalsa's representative was also present. And due deliberation after taking all points into account, Lordship, certain financial norms has to be followed. So it was explained to them. We have filed an affidavit, Lordship, along with the minutes of that meeting today. Yes, I have the extra copies also. The upcoming assembly session is from 22nd of this month, Lordship.
Mr. Saikya, beyond 9 crores, nothing has been discussed. The requirement of fund is more.
The fund, whatever fund is required, Lordship, they have to give the proposal and there are certain financial of which we cannot abandon.
I agree to whatever Respondent said, the meetings were held. And the authorities have thereafter submitted the supplementary proposal, which they had asked for. We have already submitted it on 12th of July, Your Lordship, in terms of their 12th of August, Your Lordship, I apologize, 12th of August. The meeting was held on 9th. Only one small clarification which I would like to place before Your Lordships. In serial number 4 of this minutes of the meeting, there was a issue which was raised with regard to the audit of the entire accounts, which is not happening. The reason why this is not happening is because the committee, the board, is to be reconstituted by the legislative department.
That they
which
mentioned.
they have, we pointed it out, Your Lordship, but we have been giving them reminders for almost one year now, that this needs to be reconstituted. The board is in the name of Honorable Mr. Justice encasing, as he then was the executive chairman of the
The
of the state
legal
legal.
impediment holding this back may be addressed in consultation with the legislative department.
Yes,
and prior-
that may be done on urgent basis, only then can we audit the accounts. That is the only.
Okay. Pursuant to the direction given by this court on 5/8/2024. The Advocate General, Mr. D. Sekia, has placed on record the minutes of the meeting held on 9th of August 2024 with the Additional Chief Secretary of the Government of Assam, Home and Political Departments and other stakeholders. In the said meeting, the following decisions have been taken. It's 1, 2, 9. Taking into consideration the fact that decision, the meeting in between this, the various stakeholders have already been taken place. And some decisions have also been taken. We deem it appropriate to adjourn this matter for 8 weeks. On the next date, the state as well as the Assam Legal Services Authority may submit the factual report regarding a progress in pursuant to the above decision. Where progress take place in pursuant to the above the decisions. Next after 8 weeks.
For hearing, item 42.
Well, before starting the hearing, Miller, there is one IA, Miller. Well, in the main petition, Miller, one order was passed, Miller. On the same day, Miller, two I was disposed of, Miller. On same day, but the name of the respondent was not reflected in his judgment, Miller, on particular day, Miller.
Which IA?
IA, I filed one IA there. My IA is, Miller. My IA is 3105. The petition 137/2019 was disposed of, Miller, on, Miller, 14/11/2019.
3105.
Yes, Miller. So, Miller, on when petition was disposed of, Miller, on same day, the single judge, Miller, disposed of to IA, Miller. That IA, Miller, on this one is IA 1/7/2019 and 1/9/2019. On particular date when judgment was passed, Miller. But the name of the those who are impleaded that were not reflected in the judgment, Miller. Judgment, Miller. They were impleaded in the petition, Miller, as a respondent, but their name were not reflected in judgment, Miller. So later on, I came to know their name is not there, Miller. So in order, Miller, Lordship may turn, Miller, in appeal, Miller, page 20. Page 25F, my lord. Heard Mr. PD Nair, learned counsel for the petitioner also heard so and so counsel for the private respondent 4 to 13 and and learned counsel for respondent 14 to 2018, my lord. And my last portion, my lord, page 25K, my lord. The paragraph 6, my lord, the petitioner and a newly implemented private respondent be paid the compensation for their respective land as per order award number 1 of 2019 notified so and so. So these are some of them implemented, newly implemented my respondent, my lord. But in the judgment, my lord, their name is not there, my lord.
So how it affects, what is the difference it make? Now in the appeal, these, the persons are already implemented as respondents.
No, I am not implemented. So, my lord, I filed a party implementing petition, my lord. That is before the IA number 3105 2022, my lord.
It's 2022, now you have filed this application.
No, my lord, it was filed at that time, my lord. At that time, my lord, it was filed. It was registered 2022, my lord. So it is my duty to indicate that this honorable court.
In this writ appeal, those private respondents are not party.
Because in judgment, their name were not there, my lord.
Yeah. So we just amended court pattern here at the hearing the court.
Procedural was not.
Anybody is appearing on behalf of the private respondents?
My friend is appearing.
I am appearing for the petitioners, my lord. The other newly impleaded respondents in the last day of the petition, they are not represented, my lord. Notice was not issued.
They were 14 to 18 in the petition.
Yes, my lord.
Because my lord, same day, my lord, judgment was on that day, they were implemented, but Costatel was not, name was not changed, my lord. That is there, my lord. This is one 1411, my lord. When the
Where is the judgment dated 1411?
yes, my lord. This, my lord, page, my lord, starts from, my lord, relevant 25F, my lord. This is the order of the implementing petition. On 14/11/2019 itself, my lord, I was allowed, my lord. But Costatel, their name is not there, my lord. Later on, my friend informed, my lord, there's order.
Who was the counsel for those?
Mr. Lal Fakama and late Mr. Joshwana.
They are from Mysol.
Yes,
They are from Mysol. So Joshwana is no more.
Only here, my lord, only 2 points, my lord. This one, when this judgment was passed, my lord, the Union of India is not party respondent. Correct. And my lord, this the writ court directed my lord to prepare separate award, my lord. Initially, there is a award, my lord. There's supplementary award, my lord. But so for our cases, my lord, they right to
Here in this writ appeal, you are appearing on behalf of the private respondents.
No, in the writ petitioners,
Writ petitioners, those writ petitioners are party in this writ appeal?
Yes,
Party number?
Party number, my lord, 1 to 13, my lord.
1 to 13.
My 30, my
1 to 30.
My lord.
And what about this 35 to 49?
I have state respondents, my lord, my learned friend.
My lord, 14 to my lord, this other, my lord.
Your application is here. Pray that lordship see pleased to implead opposite party number 1 to 15 as respondent number 35 to 49 in the instant writ appeal.
Yes, ma'am.
So this 1 to 15 here in this application, they has to be implemented as party. Rest of the respondents are represented.
My lord, the state respondents and the writ petitioners are represented. There were 2 IAs filed before the learned single judge.
I understand, sir. That's why only is asking that the opposite party in the applications number 1 to 15 be implemented as 35 to 49. These persons are not implemented and not represented.
My lord, other my lord, we have taken step and service was complete, my lord. Thereafter, matter was taken up, my lord. There is delay 90 days, my lord. After completion of service, my lord, my learned friend appeared. The rest of them did not appear, my lord. The other respondent, my lord. Others so far, my lord, they from respondent, my lord.
He has to file amended cost.
Though this writ appeal number 121/2020 is the 22 is listed for hearing. However, the learned counsel for the appellant has pointed out that some of the newly added respondents, some of the persons were added as respondent before the learned single judge at the time of the final hearing of the petition. However, their names were not reflected in the cause title in the cause title of the judgment, and therefore they could not be impleaded as party respondent in this writ appeal. Stop. Learned concept for the applicant has therefore submitted that the opposite party number 1 to 15 in the present IAB directed to be impleaded as respondent number 35 to 49 in the instant writ appeal. Stop. Learned consent for the respondents have no objection if such prayer is allowed. In such circumstances, this IA is allowed. The opposite party in the IA, opposite party number 1 to 15 in the instant IA be impleaded as respondent number 35 to 49 in the instant writ appeal. Learned consent for the applicant is directed to file amended cause title within a period of 1 week from today. On filing of the same, let notice be issued to the newly added respondents number 35 to 49, returnable within a period of 2 weeks through registered post and registered AD as well as Dasti.
Well, paper Dusty might not possible, madam. In Izol, madam, there is paper publication if lordship allow, madam. Because in Izol, madam, it is very difficult to.
First, the registered AD, what?
Registered AD, madam.
Registered
Dusty,
AD,
it is not.
only registered AD.
Yes, madam.
After service of notice upon the respondent, list this writ appeal for hearing. Within a week.
Within 1 week, I'll file for service.
Within 1 week, he has to furnish the cause title again.
Highly of deeply of that.
Item 43.
Make with your lordships. I know the issue that calls for consideration for your lordship is, my lord, whether the UGC regulations are to be mandatorily followed by the state while appointing the assistant professors and librarians. And my lord, one particular notification was challenged by which the guidelines were issued by the state government for recruitment of teachers and librarians. And my lord, that was not in terms of the, my lord, either UGC regulation 2010 or 2018, and on that ground, my lord, the marking system specifically, my lord, more particularly, markings are not in terms of the regulation. So that was challenged, and the honorable single judge has, my lord, held that state government has adopted only a part of it, and that is applicable, and the rest is not applicable. And
essentially, it says that the UGC regulations are not applicable to the college and under the higher education department in its entirety, except the specific provision thereof that has been adopted as indicated.
True, my lord. Now, my lord, my submission before lordship is that, my lord, the UGC regulations are mandatorily to be followed by, my lord, the universities and the states for recruiting, my lord, college teachers. And my lord, that has been, that is, my lord, that issue is no longer a res integra. That has been decided by the Honorable Supreme Court. In fact, my lord, there is division bench decision of this Honorable Court, my lord, where my lord Justice Shyam was also a my lord party. And the point was taken, my lord, earlier that it is not mandatory, but that was negated by this Honorable Court. So I'd like to place those decisions, my lord. What happened, my lord, by the impugn order, there are two parts. One part is regarding that, my lord, applicably that your lordship has just noticed, my lord. The other part is that the court has taken note of the fact that, my lord, the petitioners, my lord, present appellants, they passed out, my lord, long time back. And because of the fact that, my lord, by passage of years, the marks are increased for the students. And therefore, my lord, the persons who have passed 10, 15 years back, they cannot be, my lord, compared with the marks that has been, my lord, received by the later students. Therefore, my lord, there is a direction for rationalization of the, my lord, marks.
By the learned single there.
Yes, my lord. Now, so far that is concerned, my lord. That, of course, my lord, thereafter, when it was, my lord, urged before the authorities that the rationalization has to be taken, because that part, my lord, we are not agreed that. But then, my lord, the government took a stand that the rationalization was done much prior to the order, my lord, the notification which was under challenge in this reputation. Because of that, my lord, another reputation is pending. So, my lord, we are concerned, my lord, with that, my lord, the mandatory nature of the UGC regulations. For that, my lord, to cut a long story short, my lord, I can take your lordship to the judgments. Would be, my lord, specifically the latest one is, my lord, my lord, the judgment in, my lord, Mathivan's case, and the judgment here, Disana. I have, my lord, given the list of books. No, this file is there for you. I'm sorry, my lord. Your lordship will kindly bear with me. I have misplaced the papers. Judgment किधर दिया? Presentation को. In the, my lord, requisition, an affidavit was filed by the, my lord, Director of Higher Education, saying that the UGC regulation 2008-18 was not adopted by the government. And, my lord, in the REIT appeal, subsequently they have filed another affidavit saying that UGC regulation 2010 has also not been adopted by the government in the Higher Education Department. If your lordship kindly takes up the Gambhirdan's case, my lord, 2022, 5 SSC 179. What is it? The relevant paragraphs in
2022 5 SCC.
my lord, 2022 5 SCC 179. The relevant paragraphs are, my lord, 49 and 50. That your lordship will get at page
15.
my lord.
15.
Paragraph 49, 49 and 50.
49 and 50.
Page 206.
Yeah.
Therefore, when the appointment of the Respondent 4 is found to be contrary to UGC Regulation 2018 and the UGC regulations are having this statutory force, we are of the opinion that this is a fit case to issue a writ of quo warranto and quash this set aside the appointment of the Respondent 4 as Vice Chancellor of SP University. Then paragraph 50, it cannot be disputed that UGC regulations are enacted by the UGC in exercise of power under section 26(1)(e) and 26(1)(g) of the UGC Act 1956. Even as per UGC Act, every rule and regulation made being a subordinate legislation, UGC regulations become a part of the Act. In case of any conflict between the state legislation and the central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject of education is in the concurrent list of the 7th schedule to the Constitution. Therefore, any appointment as Vice Chancellor contrary to the provisions of the UGC regulation can be said to be in violation of the statutory provisions warranting a writ of quo warranto. Now, my lord, so far the state is concerned, my lord, there is no legislation on this. But then, my lord, there are rules which will indicate that, my lord, it has been adopted. Although, my lord, this stand in the affidavit is that, my lord, the rules have not been adopted. I mean, my lord, these
Some of the provisions have been adopted and not the whole this UGC regulations or the rules have not been adopted.
that
This
is their
what they're
stand.
standing.
That is their stand, my lord. Now, my lord, if your lordship kindly takes up the Assam College Employees Provincialized Rules 2010, that will indicate, my lord, that, my lord, the regulations have been adopted. And otherwise also, my lord, earlier the notifications were issued. I have annexed those documents also in the writ petition, which shows that, my lord, so far as the this will be page. It will start at page 496.
Yes.
This is, my lord, method of recruitment. Recruitment shall be made in the manner as prescribed herein under. Then your lordship may skip and come to, my lord, rule 7, next page. All appointment either by direct recruitment or by promotion shall be made by the director on the basis of the recommendation of the governing body based on the recommendation of the selection committee, departmental promotion committee duly constituted. The director shall communicate his order within 30 days. This is important, C, my lord. The selection committee may hold such test or interview for all posts as may be considered necessary. For posts which UGC has prescribed norms, no candidate shall be recruited without having the required norms. So, my lord, this indicates that, my lord, they are following the, my lord, the UGC regulations. And in fact, my lord, earlier, my lord, prior to this notification, which was challenged, that your lordship finds at page 79, prior to that, my lord, the government issued the office memorandum earlier, where, my lord, the marking system was, as was, my lord, in the regulation of the UGC. But subsequently, my lord, on 24/1/2022, my lord, this notification came, which is, my lord, at page 79, which was challenged in the, my lord, writ petition. Now, there are decisions of this honorable court in the division bench, my lord. It is there. Yes.
This is, this dispute is regarding selection on the post of
The assistant professors in college.
assistant professor.
Nice. My lord, may I please on decision of the summary report?
And this provision of clauses 3.00, 4.00, 4.40, and 4.41 is in relation to which post?
Same post,
Assistant.
assistant professor. Assistant professor and librarian, to be precise.
Yes.
My lord, this decision of our High Court, my lord, this is also pertaining to the recruitment of assistant professor. Paragraph 1, your lordship will find the intra-court appeal is directed against the judgment. Final order is going so passed by the learned single judge, whereby the reputation of preferred the respondent was accepted and selection of the appellant as an assistant professor, borrow pursuant to the advertisement is going to issued by principal business college was set aside. Then your lordship has keep and come to paragraph 25. Firstly, we take up submission of Mr. So-and-so, learned senior counsel, represents the appellant that the UGC regulations not having been adopted by the state of Assam are not applicable to the controversy at hand. In this regard, we may first refer to the OM dated 14/8/2015 issued by the Government of Assam Education Department, laying down the guidelines for selection of assistant professors and description of marks for ranking of candidates. This OM entered earlier provides that the same was being issued as per the UGC guidelines. That, my lord, we have annexed in the repetition. Clause number 3 of the OM dated so-and-so, providing that the teaching imparted for 1 year would entitle the candidates 2 marks of experience, further stipulated that the teaching should have been imparted by the candidates in a particular year with the standard teaching hours of a regular assistant professor as per UGC. In case of Gambhiran so-and-so, the Honorable Supreme Court has laid that controversy at rest by holding that UGC guidelines are mandatory for all educational institutions. In addition thereto, we may note, my lord, this year also we skip, my lord, then paragraph 29. By OM dated 25/6/2012 issued by the Government of Assam, the Governor of Assam adopted the clause so-and-so of the UGC guidelines, and thus there is no merit in the argument of Mr. So-and-so from the senior counsel for the appellant that UGC guidelines do not apply to the state of Assam. There is another decision of this of our High Court. Tapan Kumar Sinha. Here also Honorable Justice Shyam is a party member. Paragraph 7. The judgment rendered by the Honorable Supreme Court in the case of Gambhirdan K. Gandhi, cited by the Learned Counsel for the appellant, lays down the principle that UGC regulations would prevail in case the state act is not in conformity with the same. There is no dispute to such provision of law as laid down by the Honorable Supreme Court. However, the factual situation of the case in hand makes it clear that the Silchar College of Education had applied to the NCT for grant of recognition for students, and that part is not relevant. Now, my lord, primary grievance of the petitioner before the Honorable Single Judge was that because of the marks that has been, my lord, allotted person to that, my lord, impugned notification, office memorandum dated 24/1/22, that gives, my lord, only 2 marks for interview. And my lord, larger marks for, my lord, graduation, post-graduation, from matriculation onwards, my lord. And the purpose of the UGC regulations is to have a, my lord, uniform standard all over the country. And the, my lord, domain knowledge is important, and, my lord, for assessing domain knowledge, my lord, the interview part is important.
They followed a uniform norm for every candidate.
That,
Whether it is UGC or non-UGC,
yes.
everybody will be at equal footing, equal advantage or equal disadvantage.
No, my lord. That, my lord, the Honorable Single Judge has also noticed. As I said already, my lord, the persons who passed earlier in point of time, your lordship knows, my lord, personally, the marks which, my lord, the candidate secured, even the highest mark, my lord, is, my lord, not comparable to the marks who were passed last year. So, my lord, marks are very different, my lord. At our time, my lord, the person who secured first position in higher secondary, he did not get star marks. I'm giving an example, my lord. Now, my lord, 90-95% is a very common thing. That way, my lord, that has been noticed by the Honorable Single Judge. And that's why, my lord, the Honorable Single Judge has directed that, my lord, there should be rationalization. Although, my lord, he has held that it is not mandatory. And that is how, my lord, the petitioners are prejudiced. They passed out many years back. And only, my lord, from metric onwards, my lord, the marks are given priority, but the, my lord, domain knowledge part is not given priority, which is a precondition, my lord, in the UGC regulation, my lord, the marks that has been, my lord, distributed.
So you want a fresh selection to be done?
My lord, in fact, I am not challenging a particular selection. What happens, my lord, the petitioner, the appellants, my lord, they appeared in the different, my lord, selections. They did not go through because of the fact that, my lord, the domain knowledge part, interview part was not there. And, my lord, the persons who passed, my lord, even some were working as, my lord, honorary teachers in some colleges, their students get more marks and they get through, my lord, and can get the job. That has been noticed by the Honorable Single Judge, but then, my lord, rationalization has been directed. That has also not been done by the authority.
This is more of an academic exercise at this point.
Not necessarily, my lord. If your lordship interferes and directs that this is to be set aside, and, my lord, the marking pattern has to be as per the UGC norms, then, my lord, the petitioner can apply, and maybe, my lord, the petitioners may get through.
If we are not agreed by any particular selection, what direction now we can?
No, I'm agreed by this, my lord, notification at page 79. I say, my lord, that this is not in terms of the UGC regulation.
There is a notification,
That your lordship finds at page 79
79.
of the readable. That's why, my lord, there is no private respondent in this case.
Then those selected candidates, they will be affected. Supposing the relief you are seeking is granted, then those who are selected in the same batch, their selection will be interfered.
No, my lord, it will be only for prospective selections. The persons who are already selected, appointed, they will not be affected, my lord. I have not made any grievance against that. I have made grievance against this notification, because of which, my lord.
So you mean to say that in future, they should abide the UGC regulations and not these prescribed qualification by this
Exactly.
notification.
Exactly, madam.
So what is the difference between this, the office memorandum, the qualification prescribed in this office memorandum and the UGC qualification?
Yes, my lord. I'll show your lordship that. My lord, if your lordship comes to page 79, that is the, my lord, guidelines of selection of assistant professor librarian in provincial government model colleges issued by the Director of Higher Education. If your lordship comes to page 80, your lordship will find 80, next page, my lord.
Yes.
Conversion of EGD guidelines for standardized marking procedure of all counts in terms of the concrete marks against each item are as below. It is hereby clarified that where the university, college, institution declares results then next. Now, your lordship may compare page 56 with the, my lord, impute notification at page 79. That's why, my lord, we do not fall within the, my lord, zone of consideration.
That's another thing now, you mean to say that this notification should go?
Yes.
And they should, issue a fresh notification in, which is in consonance with the UGC norms.
Exactly, ma'am. Either they were doing the, my lord, all of a sudden they had changed it. Earlier, my lord, they were following the UGC regulations. Those notifications we have, my lord, annexed. Thereafter, there was a change.
Yes.
Regarding lawsuit, the moot question lawsuit have to decide lawsuit whether UC regulation is binding on the state or not lawsuit. And regarding lawsuit, page 56, just I clarify it lawsuit. Page 56. Page 56, what they have, just my senior science point out, page 56 lawsuit.
56.
Page 56 of the requisition. Lawsuit. It is lawsuit in respect of lawsuit API score lawsuit. Along my kindly page 56.
Page
56. 56. Page 56 lawsuit. Malon may kindly peruse first column minimum API score, second column lawsuit assistant professor equivalent cadre stage 1 lawsuit. Here the selection was made lawsuit in respect to the assistant professor equivalent cadre stage 1 lawsuit. Here lawsuit the API score is not applicable lawsuit. Here only minimum
API scores. What is
minimum
this API?
Minimum qualification as stipulated in this regulation. Only lawsuit minimum qualification is required lawsuit, no API score. Here lawsuit, the state of Assam never diluted the minimum qualification prescribed by the UGC lawsuit. Even we never enhance also, never dilute also.
Mr. Gogoi, just 1 minute. We understood your argument. But you see, in this Assam College Employees Provincialization rules
7C
of
lawsuit.
2000, yes, 7C.
7C.
Listen,
Lawsuit.
you made it clear that anybody who does not fulfill the
Lawsuit.
UGC norms
Lawsuit.
cannot be appointed as,
Lawsuit.
right?
Lawsuit.
So therefore, you can't say that you are totally ignoring the UGC rules. That you cannot say.
We are not saying that.
Correct.
Okay.
So in a subject which is governed by the UGC rules,
Lawsuit.
there if you have a criteria which is not consistent,
Lawsuit.
the candidate will obviously be prejudiced.
Lawsuit.
So those areas, those fields which are governed by the UGC regulation, your state's circular and guideline has to be inconsistent
Yes, Lawsuit.
with that.
Yes, Lawsuit. This is in respect of norms, Lawsuit. My lord, may kindly pay 7C, Lawsuit. The selection committee may hold such test or interview for all posts as may be considered necessary, Lordship. Then, Lordship, for posts for which UGC has prescribed norms, Lordship. My lord, may kindly mark it. Norms. No candidate shall be recruited without having the required norms. Here, Lordship, we are following, Lordship. There is no dispute, Lordship. We never dilute the norms prescribed by the UGC, Lordship. The norms is, Lordship, he should be a master degree, above 55% of marks in respect of general category candidate, and he should possess the required net or slab or Lordship, PhD, Lordship. That was never diluted, Lordship. In respect of Lordship, SC candidate, the marks should be 50%. It was never diluted, Lordship. The norms was never diluted by the state of Assam. We have in the OM also, Lordship. We are in the consonant of the UGC regulations. We have issued the OM Lordship. The basic grievance, Lordship, after going to the petition, I just pointed that basic grievance is, Lordship. We are not following the Lordship that is the shortlisting part, Lordship. We are call all the candidates, Lordship. All the candidates and marks was divided, Lordship. It is applicable for all. It is not a case that it is applicable for one set of candidates or it is not applicable to another set of candidates.
Now, Mr. Ugai,
Lordship.
your stand is contradictory what you have contended before the learned single.
No, Lord. Lordship,
Before
sorry.
the learned single judge, you said that we have not adopted
Lordship.
all the UGC norms
Lordship.
in toto, and we have decided to adopt some of the norms and decided not to adopt some of the other norms.
Lordship.
This is what your stand before them.
Today,
Now you are arguing that the whatever the norms you have prescribed by this notification are in consonance with the UGC regulations. Minimum, you have not compromised and you have provided some additional qualification apart from the minimum qualification.
no, Lordship. We are not providing, Lordship. We are not
What you
providing.
have submitted.
We are not providing, Lordship. Minimum qualification as prescribed by the UGC was never diluted by the state of Assam.
Never diluted.
Never diluted.
But on the other hand, you have, apart from the minimum qualification, you have mentioned some other qualifications also.
No, Lordship. No. There is no other qualification. Lordship,
Now come to para number 27 of the judgment.
27, Lordship, 27. Lordship.
Now, after 10, around 10 lines, it is the stand of Mr. M.K. Gogoi.
Lordship.
Mr. K. Gogoi,
Lordship.
learned standing counsel for the education, that in exercise of discretionary power,
Lordship.
the provisions of clause 300, 400, 440, and 4441 of the UGC regulations of 2010 as per norms of the post provided they have been adopted.
Lordship.
And in doing so, the provisions other than the aforesaid provisions have not been adopted.
Lordship.
This is what your stand.
This is the findings of the Honorable Court, Lordship. We have,
Huh?
this is
the
the,
finding. This is your stand, sir.
Lordship,
They have noted your stand.
Lordship, we have said that, Lordship, the minimum qualification which is prescribed by the UGC, Lordship, and the OM which was issued by the government of Assam.
Here it appears that you are standing altogether different.
Lordship, no, Lordship.
You
This is-
said that only these clauses, clause 3.0.0,
Lordship,
4.0.0, 4.4.0 and 4.441
Lordship,
have been adopted and others have not been adopted.
Lordship, that is adopt in the tune of the UGC's regulation. It is as per our OM also, Lordship. This is in respect of qualification part, norms part, Lordship. This is in respect of norms part, Lordship.
So prescribed UGC and prescribed norms for the post therein have been adopted and doing
Lordship.
so the provisions of other provisions are not adopted.
Lordship,
And in the earlier part of this para,
Lordship,
your stand was that it is not mandatorily applicable.
Lordship,
It's only directory for us
Lordship.
because the UGC is not providing any funds for
Lordship.
to us.
Lordship. It is our submission. Today also, Lordship, today also I reiterated that submission as because, Lordship, we never dilute the UGC's minimum required qualification prescribed by the UGC, Lordship.
Sir, you are absolutely, now your contention is totally altogether contrary to this earlier submission, sir. You simply said, "Okay, we have adopted only these 4 clauses and other clauses we have not adopted."
Lordship.
This is what your stand is.
Today also, this is our stand, Lordship. This is that particular clause is, Lordship, in respect of the norms, Lordship.
So your stand is,
Lordship.
since the UGC is not providing any funds
Lordship.
to the colleges,
Lordship.
and therefore these UGC regulations or norms are not mandatory for you.
Lordship.
This is what your
Lordship.
stand is.
Lordship.
On the basis of what? After this judgment of the Honorable Supreme Court in Gambhiri case, Gambhir.
Gambhir, before Gambhir, there is a 3 judges bench judgment is there. This is not placed before this honorable court. Even that was not considered by the honorable apex court also. I will place that judgment, Lordship. Even Gambhir also not discuss the law and dictum given by the Lordship.
In Gambhir, you mean to say that Gambhir?
Lordship.
No,
Even Lordship, that part was just now, Lordship, I pointed out one thing, Lordship. I will place everything, Lordship may give at least half an hour time, I will place everything. Before that,
we are here.
Lordship.
We are hearing you.
This is not my view, Lordship. That Gambhir is the not the law laid down by the Honorable Apex Court is not my view, Lordship. It is the view of the one of the coordinate bench of the Honorable Supreme Court, Lordship.
Please don't go by this.
Lordship, just Lordship may just have a look at it, Lordship. After that, I will advance my argument. Just Lordship may only one copy is, I am extremely sorry, Lordship, kindly. When issuance of the notice in another case, Honorable Supreme Court says that, Lordship.
What has happened in this case?
This case was, Lordship, unfortunately, Lordship, that particular case was against before the same honorable bench, Lordship, said who passed the Gambhir judgment, Lordship. So he
now it's nothing.
just I point out, Lordship. Just I point out.
Unfortunately or fortunately
Lordship.
for others,
Lordship.
unfortunately for you,
Lordship.
can't do that.
Lordship. After Gambhir also, two judges bench of the Honorable Supreme Court is there. There is a contrary view. I will place everything, Lordship. I will place everything, Lordship.
Sure.
Lordship. So at first, my Lord may kindly peruse the judgment of the Honorable Supreme Court 2015 6 SCC 363, Lordship.
Kalyani.
Kalyani Mati Badam, Lordship. This is the law laid down by the Honorable Supreme Court that was never discussed in the Gambhir cases. So my Lord may kindly peruse paragraph 62, Lordship. No.
By the control.
You lost it, I mean, I can read lost it. You lost it, I mean, I can.
Yes. This was the two bench judgment.
Lost it, two judges bench husband.
Two judges bench.
Lost it. Paragraph 62 lost it. Lost it, I mean, I can read it, lost it. In the Gambhiran judgment, Lordship, in paragraph 7.8, Lordship, only mention the death, Lordship, Kalyani Mativaran case. My lord, may kindly peruse paragraph 7.8.
Annamalai and Kalyan.
7.8.
and Kalyani, both the judgments have been referred to.
Only 7.8, they have only mentioned the judgment. But the dictum which was given by the Honorable Appeals Court was never considered in the judgment, Lordship.
Okay, what is the dictum?
Dictum is, Lordship, page 62, Lordship, paragraph 62, Lordship.
Yeah.
In view of the discussion as made, we hold, Lordship, 62.1, to the extent the state legislation is in conflict with the central legislation, including subordinate legislation made by the central legislation, under NT 25 of the concurrent list, shall be repugnant to the central legislation and would be inoperative, Lordship. Then, my lord, may 62.2. UGC regulations being passed by both the houses of parliament for a subordinate legislation has binding effect on the universities to which it applies, Lordship. Then, Lordship, the UGC regulation 2010 are mandatory to teachers and other academic staff in all the central universities and colleges thereunder, and the institutions deemed to be universities whose maintenance expenditure is made by the UGC, Lordship. Then, my lord, 62.4. The UGC regulation 2010 are directory for the universities, colleges, and other higher education institutions under the purview of the state legislation, as the matter has been left to the state government to adopt and implement the scheme. Thus, the UGC regulation 2010 are partly mandatory and partly directory. I am relying that. And this was never discussed before the Honorable Supreme Court in the Gambhiran cases. Sorry. No.
Another which judgment?
And my lord, the facts of that Gambhiran judgment is totally different here.
That is in respect of appointment of vice chancellor.
Even lordship, the UGC's regulation was adopted by the state of Gujarat. So my lord may kindly peruse the paragraph 28, lordship, of Gambhiran judgment, lordship.
Oh, leave it, leave Gambhiran. You are citing another judgment, latest judgment.
Yes, because that was adopted. So Honorable Court view is that it was earlier adopted. Now amendment part, they cannot say that it cannot be adopted. That's why the Gambhiran judgment was passed by the Honorable Division Bench of the Supreme Court, lordship. Then my lord make Dhara Objection 2013 8 SCC 630. Jagdish
No,
Prasad.
no, after this Gambhir Dan judgment, you are referring to one judgment.
Lordship.
Show us.
Dhara AIR 2022 SC 1767. And Gambhiran was passed in the month of March, Lordship, and it was in the April, Lordship. Gambhiran judgment was Gambhiran was 3rd March 2022, Lordship, and this was delivered on
7-4.
7-4, Lordship. Paragraph 20, Lordship.
Noticing this Gambhir Dan,
Lordship.
Gambhir Dan, they have taken note of it.
This is even, Lordship, after Gambhiran, another 2 judgment come from the Honorable Apex Court. That was also not considered, Lordship. I will place that judgment also, Lordship. There is a conflicting view of the Honorable Supreme Court, Lordship. And so, Lordship, that 3 judges bench judgment will be revealed, that will I will place, Lordship.
Yes.
Paragraph 20, Lordship.
2-0.
Lords.
From facts. Yes. Read.
Lordship. Paragraph 20, Lordship. Context, Lordship. We have recorded the facts in the preceding paragraphs. Law has become quite settled that the appellant is not bound by any direction issued by the central government, which would at worst be mandatory to the central universities and the central government colleges receiving funds. Thus, any such decision would obviously as directory to state government colleges and universities being in the nature of a mere recommendation. The appropriate position has been clarified by the decision of the Kalyani Mati Vedon cases, Lordship. Then, Lordship, UC Regulation 2010 are directory for the universities, colleges, and other higher education institutions under the purview of the state legislation, as the matter has been left to the state government to adopt and implement the scheme. Thus, the UC Regulation 2010 are partly mandatory and partly directory.
Yes.
Then, my lord.
So this decision is quoted Kalyani Mathivanan with approval.
Lordship. Yes, because Kalyani Mathivanan paragraph 62, Lordship. Paragraph 62 was the dictum of the Honorable Apex Court. That was, Lordship. And my lord, then 2013, 2013 8 SCC 633. It's a 3 judges bench of the. Oh, excellent. 633. It's a 3 judges bench of the Honorable Supreme Court, Lordship. Here I am relying paragraph 72, Lordship.
Paragraph
72, Lordship. Other judgment, all are 3 judges, Lordship. 2 judges, Lordship. This is the 3 judges judgment, Lordship. If Lordship permit, I can read it, Lordship. Paragraph 72, Lordship. As far as the state of Kerala and UP are concerned, they have their own problems which are localized and stand on a defined footing from the other states, none of whom who appears to have the same problem. Education now being a list 3 subject, the state government is at liberty to frame its own laws relating to education in the state and is not therefore bound to accept or follow the regulations framed by the UGC laws. It is only natural that if they wish to adopt the regulation framed by the Commission under Section 26 of the UGC Act 1956, the state will have to abide by the condition as laid down by the Commission. This is the 3 judges bench judgment of the Honorable Supreme Court. By following that judgment, another judgment came, Lordship. It is after the Lordship Gambhiran judgment, Lordship. It is delivered on 02/08/2022, Lordship. That right, Lordship? 2022 SCC online SC 958 দ্বারা 958 it is after Gambhiran lawsuit. Paragraph 31 and 32 lawsuit I am relying lawsuit. In above paragraph lawsuit, the judgment which was delivered by the Honorable Three Judges Bench was referred lawsuit in paragraph 30. Then my lord kindly come to paragraph 31 and 32 lawsuit.
Yes.
31 lawsuit. It is not understood how those paragraphs are of assistance to a appellant. There is no finding in paragraph 68, but only discussion of facts which led to the decision, and paragraph 72 is clearly against the appellant. This court unequivocally held that the state was not bound to accept or follow the UGC's regulation. That is the judge's bench judgment, paragraph 72 lawsuit.
Why not bound by this? The state has not adopted.
Not
this
adopted
law?
lawsuit, not adopted state. The state is not adopted, so state is not bound lawsuit. And lawsuit paragraph 32 also says that it is well settled that a judgment is a precedent for the issue of law which is recited and decided. Discussion in a judgment cannot be read out a context and imparted as a dictum of the court. Here lawsuit in the Gambhiran case lawsuit, only reference was made lawsuit regarding Matibatan case. And there is no
This luxury is available to the Supreme Court, not.
lawsuit,
This luxury is not with us to make such comments.
lawsuit. And I will also refer one of the judgment of the my lord High Court lawsuit.
My lord's High Court is.
My
this Assam High Court,
earlier my lord High Court. I am extremely sorry, lawsuit. I am extremely sorry, lawsuit.
Yes.
There are 2019 Zero Supreme Court Junction, Rajasthan 575. It's a division bench judgment of the Honorable Rajasthan High Court lawsuit. Hex is in paragraph 1 lawsuit, then I am relying paragraph 21, 24, and 25 lawsuit. It's a division bench judgment of the Honorable Rajasthan High Court lawsuit.
21.
Lawsuit 21, 24, and 25 lawsuit.
That apart, neither factual findings laid nor the documentary evidence of his revenue map, etc. So and so. 24.
Lawsuit 24. 24 discuss about lawsuit Kalyani Matibatan cases lawsuit. And 24 is sufficient lawsuit.
20 fortified judgment apex court so and so in India. The right single the deemed to the only reason assigned by the district High Court for upsetting the well considered order pass negating position was declared under section for the process of dealing the doctor were reporting the appeals to this judgment, which judgment you are referring to?
Lordship?
It is in relation to land acquisition.
No, lawsuit. 2019 Zero Supreme 575.
575. 515. 573.
57 575. 575. Also, only one copy is there. One copy. You can read it. You can read it. Also, paragraph 21, 24, and 25.
21.
21.
As is apparent from the factual discussion above, the issue which court has to decide legality of two university pursuant to the amendment Yes. Para 24,
24 and 25 also, Lordship.
25,
24, Lordship discussed about Kalyani Mativadam.
all the people.
Yes.
The query can find on the opinion of the state, there are two places. Which one should be? Sir, Chaudhary, you need some, you need to give some answer about this. In fact, this Gambhir Dan, actually, on which you are placing reliance, there the state government has adopted the regulations and they have also, the university where the vice chancellor was appointed was also getting central assistance.
Yes.
This was the case in that facts of the case, the court has said, okay, no, those are binding. But here now, looking to this Kalyani judgment and other the judgments on which is placing reliance, you are required to
My lord,
either you answer those questions or what?
my lord, my first submission will be, my lord, the ratio of the case is, my lord, it has to be understood on the backdrop of that case, my lord, facts of this case, my lord. And my learned friend is relying on Mathivahan, Kalyani Mathivahan, and my lord subsequent judgments where my lord
Then consistently, the Supreme Court has held that
Yes.
these, when in the absence of adoption of these UGC regulations, those UGC regulations are not binding, not mandatory.
Now, my lord, my submission before your worship will be that, my
No,
lord.
you are free to make your submissions. If you want some more time for this to meet this argument, then it's
That will
okay.
be-
Otherwise, you can very well argue the matter.
That will be better, my lord. Because the decisions he has cited, my lord, some of the decisions I have not even got the, my lord, citations. So we have, my lord.
Supply the copy. And you do one thing, one compilation, you also
Lord,
make
I'll provide.
regarding this,
Lord, Lord.
the relevant paras and judgments. In compilation, you also submit.
That will be fine.
27th of August, 28th. 28th of August. The arguments heard in part, list on 28th of August.
Supplementary list, item 49.
All the judgments which you are relying on,
Lordship?
on all the judgments.
Lordship, I'll make a
Make a
compilation.
convenience compilation.
Lordship, I'll do.
All the High Court, Supreme Court.
Lordship, I'll do. Lord, I'll do. Oblige, Lordship.
Yes, Mr. Roy.
May please, Lord.
You were, yesterday you were required to show one.
Yes,
Where is that?
yes. Next page 482, Lord.
480,
Yes, sorry.
which you have already referred, sir.
First of all, Lordship, I am pleased to come to page 401.
First of all, go through
401.
482, just a 482. Yes.
Yes. Lord,
This
relevant.
starts from 481.
Yes, it starts from 481, Lordship.
Yeah.
This is a letter given by the Executive Director, Project Lordship, to the Director Technical NHIDCL Lordship, New Delhi, stating therein third para Lordship. Apart from that, certified by AE means authorized engineer. As per work done, there is outstanding work of so and so, and the work done which was to be paid. However, the contractor has not submitted any proof of payment to the subcontractor, nor the subcontractor has given any undertaking that they have received the payment. Therefore, the payment of this much cannot be reimbursed to Messrs. Portion Carbium, that is the main contractor. It may mention here needs that the subcontractor are making a representation to the MD, NHIDCL for payment of their dues to them. In this regard, a meeting was held at headquarters with subcontractors, with the Director Technical and Director of MSGDCL, wherein it was decided that the contractor would raise the bill with GDCL and this payment shall be made to them through the GDCL. Accordingly, the termination payment of so payable to EPC contractor, portion Carbium and rupees this and that payable to subcontractors of the electrical utility through GDCL is recommended for further consideration.
Sir, where is the direction by the chairman of the whatever this NHIDCL to make payment to the petitioner?
No, by chairman, there is no such order law.
So you said yesterday.
No,
and
there
you
are other there are other annexes. Lordship, may I
you
please to
took
come.
time to search out that document.
Yes.
Then you were supposed to, yes, 401.
401 Lordship. This is the affidavit in opposition filed by the appellant's Lordship.
Fine.
401, where they have admitted the amount. It starts from page 399, Lordship.
Yes.
This is the affidavit in opposition filed by the present appellant, Lordship. And Lordship, will please to come to para 11, page 401. That with regard to the statements made in paragraph 27 and 28 of the writ petition, the answering deponent begs to state that in consequence to the termination of the contract of 4 laning from Jorhat to Jhansi section of NS 37 due to gross default on the part of the previous EPC contractor, MS Portion Carbium Construction SA, authority engineer determined the valuation of unpaid work, completed and uncompleted, as per the provisions of clause 23(5) of article 23 of the contract agreement. The gross valuation of the unpaid EPC work completed, uncompleted, determined by the authorized engineer is rupees 12 crores 26,35,331. 331, and out of which executed under a scope of the subcontractor MS Green Deca, that is the writ petitioner Lordship, is rupees 11,685,770, and under a scope of other subcontractor is rupees 1 crore 90,49,550. So this is the one of the admission law that the writ petitioner is entitled to, who had executed the work for more than 11 years, Lordship. Then
Oh, resolution. इसमें लेयर को करने देना technically provision to separate that technology that we have done on what is and then here means create termination is like overriding but these order that is significant. That is these factors. The only question is payment. No, it's overriding contractual rights for the main contract. Oh, I will run. No liability. I will take it from you. But that cannot be a ground to deny him sales because he is some statutorily protected and is not subjugated. So whether the contract is binding on him or not, most of them are denying like that.
That's all.
No, I have to place these citations, Lordship. One, there is a Supreme Court decision also, Lordship, under the MSME Act that before filing the appeal, 75% amount.
75% will not entertain. So that is altogether different because that is in relation to a decision of the council or dispute resolution authority. It's not
Or
the High Court
or
single
any
judge
other
is-
institution. So, Lordship,
Sir,
High Court is
institution,
also
High
an
Court can't be treated as an institution, dispute resolution institution
That
and
is
the
your
council.
Lordship.
That can't be, no. You don't.
Citations I have.
Order is there.
submitted.
Order is there.
Lordship,
Argument, sir. Order is there.
Lordship, one judgment I would like to, some say really full bench decision of the Honorable Court. Only
What?
some, that if the amount is certain.
Sir, please don't go into this. You're considering on merits, then it's okay, please.
Mr. Roy, we are surprised that you have still not understood what is happening.
Lordship, I am ready. If your Lordship.
Your
please-
client may end up getting 100
No,
rupees.
Lordship, if your Lordship refer the matter to the Industrial
We will.
Facilitation Council, I have no objection. Because I will be more benefit.
Then why are you opposing it?
No, I am not opposing, Lord.
You are opposing it. You are referring to this.
No. Lord,
75% and all.
I am not opposing.
Don't go for it.
Sending
They
the
should
matter
have
to
been
the-
smart and say that we'll pay 11 crore and finish it off. Now there is no escape from the statutory liabilities.
Yes, I am ready, Lord. The matter will be
Okay,
referred
we'll
to
pass.
the Industrial.